hello, 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 hello. Those who have not done the registration, please complete the registration process. Our volunteer teams are there at the registration desk outside the hall. Those who are left for registration, please go and complete the registration process. Because many students and participants have entered through this gate. If they have missed to register themselves, please go to the registration desk and register yourselves. Thank you. Hello, hello, hello. Hello, hello. Those who are sitting at the back side, I request them to come forward, please. We are about to begin the program. Those who are seated in the back side of the hall are requested to come at front. I would like to request those who are seated at the back of the hall, please come forward. morning, everyone. It gives me immense pleasure and a great sense of honor to welcome you all to today's IP workshop on turning ideas into assets, practical understanding of patent and copyright. This workshop, organized by the Intellectual Property Rights Cell of University of Calcutta, reflects our institution's continued commitment to promoting innovation, research, and awareness about intellectual property rights. In today's rapidly evolving world, ideas are powerful, but when they are protected and nurtured, they become valuable assets that contribute to knowledge, entrepreneurship, and national development. We are truly privileged to have among us such distinguished dignitaries, respected speakers, faculty members, researchers, and enthusiastic participants who have joined us to make this workshop meaningful and impactful. Your presence today truly adds value to this important initiative. We shall now begin with the inaugural session. We are truly honored to have with us our esteemed dignitaries, Honorable Vice Chancellor of University of Calcutta, Professor Ashutosh Ghosh sir, Honorable Deputy Registrar, as well as the coordinator of RUSA 2.0, Dr. Shubhamay Kisku sir. Shortly, Registrar sir will also join us. We are really privileged to have your gracious presence with us today. Now, I humbly request the dignitaries to kindly take their seats on the dais and grace the occasion. At first, I would like to request our Honorable Vice Chancellor, sir, Professor Ashutosh Ghosh, to come to the dais and take his seat, please. Along with him, I would also like to request the Deputy Registrar of University of Calcutta, Dr. Shubhamay Kisku, sir, and the coordinator of IPR Cell, who is also the founder of the Intellectual Property Rights Cell, University of Calcutta, Professor Shobhuj Kumar Chaudhary. I would also like to request our guest speaker for today's workshop, who is also present among us, Sri Shantanu De, to come to the stage and take his dais, please. It is a matter of great honor for us that the inauguration will be carried out by our Honorable Vice Chancellor of University of Calcutta, Professor Ashutosh Ghosh sir. I would like to request our team to make the watering of plants set ready. We will inaugurate this event through the ceremonial watering of plants. This act of nurturing a plant beautifully symbolizes growth, sustainability, and the continuous development of knowledge and innovation. Just as a plant requires care, protection, and the right environment to flourish, ideas to need guidance, support, and protection to grow into valuable assets. In the context of today's workshop, this gesture reflects our commitment to nurturing ideas and transforming them into impactful and protected intellectual property. May I now humbly request our Honorable Vice Chancellor, sir, to kindly inaugurate today's workshop through the watering of plants. I would also like to request Deputy Registrar, sir, as well as Coordinator, sir, and Sri Shantanu De to assist him. Now, I would like to call upon stage to the dais our Honorable Vice Chancellor of University of Calcutta, Professor Ashutosh Ghosh sir, to share his valuable insights with us so that he can encourage the participants for today's workshop. Sir's guidance, support is really meaningful for us. Without him, we would not have been possible to organize this event. So I would like to request, sir. So before calling Honorable Vice Chancellor sir to the dais, I would like to request Professor Shobuj Kumar Chaudhary to come to the dais and deliver the welcome address.
A very good morning to you all. On behalf of the University of Calcutta, I, Professor Dr. Shobuj Kumar Chaudhary, Founder Coordinator of the IPS Cell, University of Calcutta, wishing you all, my respected colleagues from our university, affiliated colleges, dignitaries, speakers, research scholars, participants from other offices, institutions, and my beloved students, a very warm welcome to this fourth IP workshop on turning ideas into assets. Practical understanding of patent and copyright of the intellectual property rights cells at the University of Calcutta. We are lucky enough to have highly inspiring university authorities like Professor Dr. Ashutosh Ghosh, our Honorable Vice Chancellor Sir, our Honorable Register, Nodal Officers, RUSA 2.0, Professor Dr. Debashish Das. However, currently he is not there, he will be shortly coming. Coordinator RUSA 2.0, Dr. Shubhamay Kisku, and Deputy Register, University of Calcutta. Without their constant support, encouragements, and cooperation, this workshop would not have been possible. The dream of this IPS cell would have never been realized if we did not have our financial support from the RUSA 2.0 and the DSTVT of the Government of West Bengal. I am thankful again to our Honorable Register and Nodal Officers, RUSA 2.0, Professor Dr. Debashish Das, Coordinator RUSA 2.0, for extending their wholehearted support and cooperations by providing this beautiful centenary auditorium for today's workshop. Our intellectual property rights sales was established on 22nd March 2024. This IPS cell is aimed at nurturing a culture of creativity and fostering an innovations and creative ecosystems in the University of Calcutta, and even it's beyond to promote grassroots or frugal innovation spread across the state. The University of Calcutta has a rich legacy of academic excellence and a proud traditions of producing pioneering research that has made enduring contributions to society. With this workshop, again, we reaffirm our dedication to not only generating cutting-edge research, but also protecting our commercializing intellectual assets that emerge from our academic endeavors. We are happy to have speakers among us, Sri Shantanu Dey, Joint Controller of Patents and Designs, CGPDTM, Kolkata Government of India, Dr. Hemant Khosla, Assistant Registers of Trademarks, Geographical Indications and Copyright, Government of India, Dr. Moham Chaudhary, Scientist C, Nodal Officers, Patent Information Center, WBSCST, DSTVT, Government of West Bengal, and renowned IP attorneys, Advocate Anjan Sen and Associates, and myself will be sharing with you on all practical aspects of patents and copyright, IP policy of the University of Calcutta, and other IP rights. Thank you once again for gracing these occasions with your presence. Together, let us embark on this journey towards a future fueled by innovations, creativity, and intellectual excellence. Thank you. Thank you, everyone.
Thank you so much, the coordinator and the founder of IPR Cell, Professor Shobuj Kumar Chaudhary, for setting the tone of today's workshop by delivering the welcome address. It was his foresight and dream initiative that led to the establishment of the IPR Cell in our esteemed university, creating a dedicated platform that not only protects innovation but also nurtures it, empowering students, researchers, and faculty members to think beyond ideas and move towards impactful and protected creations. His unwavering commitment to strengthening the culture of intellectual property awareness has significantly contributed to fostering an environment of innovation, research, and responsible creativity. And also I would like to thank the administration of University of Calcutta, because without the meaningful and the valuable support of Honorable Vice Chancellor Sir, Honorable Registrar Sir, as well as respected Deputy Registrar Sir and all the coordinators of the RUSA, this cell becoming a success, becoming a reality would not have been possible. And now we arrive at a very special and a significant moment for today's program, the felicitation ceremony. This is not merely a formal gesture, but a heartfelt expression of our deep respect and sincere gratitude towards those who have enriched this platform with their presence and wisdom. It is our privilege to honor the distinguished personalities who have taken out their valuable time to guide and inspire us today. To commence the felicitation ceremony, I would like to respectfully invite Professor Shobuj Kumar Chaudhary, the coordinator and the founder of the IPR Cell, University of Calcutta, to kindly felicitate our esteemed dignitary and the chief guest of today's workshop, Honorable Vice Chancellor of University of Calcutta, Professor Ashutosh Ghosh sir. A round of applause, please, for this wonderful moment. I would again like to request Professor Shobuj Kumar Chaudhary to kindly present our heartfelt token of appreciation to our Deputy Registrar of University of Calcutta, as well as who is the coordinator of RUSA 2.0. Next, I would like to request the Research Assistant of IPR Cell, University of Calcutta, Dr. Ujjaini Roy, to come forward and kindly present a token of appreciation to Sri Shantanu De, the Joint Controller of Patents and Design, CGPDTM, Kolkata. Please give a round of applause for this wonderful appreciation moment. Now, it's time for all of us to listen to the valuable words of the Honorable Vice Chancellor of University of Calcutta, Professor Ashutosh Ghosh sir. I hope you all will be encouraged and motivated after his valuable insights to attend this workshop and to be creative and to be innovative in the future time. Thank you.
Good morning. So I think all of you are waiting to know about this IP workshop. Just I would like to know, I really don't know whether all of you are the research scholar or the students of the master degree also. All of you are the research scholar? Students of master, student of master. So how many of you are the research scholar? There are some research scholars, some master students, and some faculty members. All of you understand Bengali or all of you understand English only? All of you understand English, good. So now do you know why you are here? Do you have any idea why you are here? So do you have any idea about the IP cell or IP? Do you know what is IP? Any of you have any idea? What is IP? Intellectual property. What is intellectual property that you know? Any property? Which property is intellectual property? Okay, so now you know intellectual property is that you are doing some kind of research. There are some ideas which is originated by you. So you need some kind of protection for that idea. You need some kind of patent for that idea. Probably, you know, for any innovation, for any, you know, novel idea, you need some kind of patent. Even for the Rasgulla, you need patenting. You know, you can prepare the Rasgulla. For the Basmati rice, you need the patent. For anything which is originated by you, you need some kind of patenting. Usually, most of us who are doing research, you know, in the university, what we have seen, that the people are not that much aware of the patenting or of taking a patent. Mostly what we are doing, we are now doing research and publishing that research as a research paper in journal, in some national journal or international journal. Usually we are doing this. But we should, you know, the research is not just publishing paper. Research, the society is giving you money for doing research, so society expects something from you. And you have to, you know, translate your research for the betterment of the society. You should innovate some idea. This is the research. And for that research, you need some kind of protection. So here, I think for this today's seminar or one-day seminar, this is today's seminar, workshop. This one-day workshop, you will learn how to protect your intellectual property. That is very important. Whenever nowadays you will not get any grant if you cannot explain that doing the research, your research will be beneficial to our society. Our society will be benefited by your research. And that part, you know, is very important. So for that, you need some kind of incubation cell. We need some kind of incubation cell. You need, we are now also encouraging entrepreneurship, that with your ideas, you can do something, you know, that you will not apply for the job, you will give job some other people. So you need to do some entrepreneurship, you start some business, you start some manufacturing or some other thing by which the other people will be employed. So that kind of idea should be there. So everything will be explained. I think there are experts in this field. So you please listen, and I will be very happy if I see that some of you really get benefited and do some patenting. And whenever you do, you take any kind of patent, and if you are the students or the teachers or the research scholar of a university, say of Calcutta University, you have to give the name of Calcutta University, because you are patenting it. You are getting the patent, but for the research, for this intellectual property, you used the infrastructure, the money of Calcutta University. or the library of the Calcutta University. So the name of the Calcutta University should be there if any of the students or the research scholar or the faculty members get any patent. So I request our experts to explain all these things, because we have seen that in many, many patent are granted by the research scholar or the teachers of the Calcutta University, but the name of Calcutta University is not there. This is not really a good practice, I would say. So you should know, all that there are some legal aspects also for patenting. That part also you should know, because if you don't know the legal parts, you cannot get the patent. Patent is not just doing research, and I won't say much. Only one thing I will say, earlier people were not that much interested in getting patent. I will give you one example. Probably all of you know the name of Marie Curie. When Marie Curie was asked to get patent of the radium, which she discovered, which she isolated, radium and polonium. When she was asked, you please get a patent of that, she told that I will not take patent of this radium, because this discovery, if I take patent, many people will be deprived of that, because that time, the radium was used for the therapy of the cancer. So if I take patent, many poor people, they will not get the benefit of this radium, of this therapy. So I will not take the patent. There are something like this. But in general, all of us, I believe that we should take patent of any kind of discovery, especially which will be translated into the practical purposes of the human being. So thank you all. I am not an expert, so I hope that everything, you will learn many things, and thank you for coming.
Thank you so much, Honorable Vice Chancellor of University of Calcutta, Professor Ashutosh Ghosh sir, for sharing such an important message and such valuable words with us. We also have in the second session Advocate Anjon Sen with us to discuss the legal aspects of patents also, which sir was mentioning. It is really very important for all of us to know the legal aspects of intellectual property. Once again, a big round of applause for our Honorable Vice Chancellor sir for such a beautiful message and for such a meaningful message for the faculty members, for the students and for the researchers. Now I would like to request Dr. Hemant Khoshla, our guest speaker, who is the Assistant Registrar of Trademarks, GI and Copyright, Government of India, to come to the stage and take his seat, please. I would like to request Professor Shobhuj Kumar Chaudhary to felicitate our today's guest speaker, Dr. Hemant Khoshla. A big round of applause. Now, I would like to request the Research Assistant of IPR Cell, University of Calcutta, Dr. Ujjayini Roy, to come forward and felicitate the Coordinator of IPR Cell, Professor Shobhuj Kumar Chaudhary. A big round of applause for this wonderful moment. Before moving to the session, I would like to request one of the important person whose contributions has really mattered in running the IPR efficiently. We have always got the support and coordination from his side. I would like to request the Deputy Registrar of University of Calcutta, who is also the coordinator of RUSA 2.0, Dr. Shubhamay Kisko sir, to come to the dais and share his valuable words.
Respected Honorable Vice Chancellor, Professor Ashutosh Ghosh, respected Professor Sobuj Kumar Choudhury, Coordinator IPR Cell, Registrar Sir is not here, delegates on the dais and of the dais, distinguished speakers, faculty members, research scholars and dear students. Very good afternoon. It is indeed a privilege for me to be present here as guest of honor in the important workshop on turning ideas into assets, practical understanding of patents and copyrights. In today's academic and research ecosystem, we are continuously generating ideas, innovations and knowledge. However, one fundamental question often remains unanswered. What is this question? It is how do we protect what we create? This is where intellectual property rights become crucial. IPR is not merely a legal framework, it is a bridge between innovation, ownership and societal impact. From my experience as coordinator of RUSA 2.0, I would like to highlight that the University of Calcutta is currently undergoing a significant transformation in terms of research and innovation. Under RUSA 2.0, we are actively supporting interdisciplinary research projects, promoting innovation and technology development, encouraging public humanities and community-based research. For example, development of low-cost biomedical diagnostic tools for rural healthcare, work on water purification technologies and environmental monitoring systems, research on renewable energy and sustainable models, digital documentation of cultural heritage and community archives. Now, these are not just the research outputs, these are intellectual assets. And without proper IPR mechanisms, such valuable outputs may remain unprotected, unrecognized, or even misused. This is where the IPR cell of the University of Calcutta becomes extremely important. It plays a key role in guiding faculty and researchers on patents and copyrights, helping in protection and management of innovations, creating awareness about intellectual ownership and commercialization. Workshops like these are therefore not just informative, they are capacity building platforms, preparing our academic community for the future. Going forward, I believe the university can further strengthen this ecosystem by creating department-level IPR support system, linking IPR cell with innovation hubs and incubation centers, developing structured pathways from research to commercialization, protecting digital outputs, data sets, and cultural activities, and building capacity among students and scholars through the IPR training. In addition, we must also evolve framework to protect indigenous and community knowledge systems, which are often left outside from formal IPR structures. To all the students and scholars present here, I would like to say, do not just create knowledge, learn how to protect it, manage it and transform it into meaningful assets. Because in today's world, ideas are powerful, but protected ideas are transformative. Let me conclude with one thought. If research in the engine of the university, then IPR is the mechanism that ensures it value and protected, sustained and translated into impact. I sincerely congratulate the IPR cell, especially Professor Sobuj Kumar Choudhury and all organizers from taking this important initiative. Thank you.
Thank you so much, sir, for your valuable words. We are also very happy to have the presence of other dignitaries among us, starting from the Controller of Examination, University of Calcutta, Inspector of College, University of Calcutta, Secretary, UG Board of Studies. First, I would like to request our controller, sir, to come to the stage, and I would like to request Professor Shobuj Kumar Chaudhary to felicitate him. I would like to request Controller, sir, University of Calcutta, Dr. Jayantos Sinha, who is the Controller of Examination, University of Calcutta. Professor Shobuj Kumar Chaudhary is felicitating him. Please give a round of applause for this beautiful moment. Thank you so much, sir, for your precious presence. Now I would like to request the Inspector of Colleges of University of Calcutta, Dr. Diptendu Chatterjee, to come to the stage. I would like to request Professor Shobuj Kumar Chaudhary again to felicitate our Inspector of Colleges of University of Calcutta, Dr. Diptendu Chatterjee. Please give a round of applause. Thank you, sir. Now I would like to request Secretary UG Board of Studies, Gurupodo Soren sir, to come to the stage. I would also like to request Dr. Ujjaini Rai to felicitate sir. Thank you so much, sir. Now, with the successful completion of the inaugural and the felicitation segment, we now move forward to the technical session of today's workshop. Before moving to the session, I would like to introduce our first guest speaker, Dr. Hemant Khoshla. Sir is presently serving as the head of the Trademarks Registry, Kolkata, and brings with him vast experience in the field of intellectual property. He has proudly represented India at international platforms including Tokyo, Japan, and Seoul, South Korea, in discussions on artificial intelligence law. Sir has been nominated 3 times from India as a member of the Standing Committee on Copyright and Related Rights, reflecting his significant contribution to the global IP framework. He is also a recipient of the prestigious Call of Honor from the Honorable President of India, recognizing his outstanding service. His expertise extends to international negotiations, where he has been actively involved in handling free trade agreements with regions such as the European Union, United States, and Canada. Academically, Sir holds qualification including MBA Finance, LLM, and a doctorate in IPR, and has completed more than 15 specialized courses from the World Intellectual Property Organization. Importantly, he has earned his doctorate from CCS University International Trademarks Registration, further strengthening his expertise in this domain. He has also contributed to academic literature, authoring works on trademarks published both in India and internationally. Sir, with such an impressive and distinguished profile, we are truly honored to have you with us today. May I now request you to kindly deliver your lecture and share your valuable insights with us. The stage is yours, sir. Thank you.
Thank you for inviting me here. I'm very delightful कि I am going to deliver a lecture on copyright. It's a very valuable word stated by a Vice Chancellor regarding intellectual property rights. I started my career in trademarks in 2011. Earlier, I did my specialization in intellectual property rights in the year of 2002, and since then I am learning intellectual property right from the different platforms. Today is one of the platform as well. Without wasting any time, let's come to the topic, which is copyright. So, what copyright is? What is the subject matter of the copyright? This is the one question. Suppose you are having any sort of idea in your mind, and when that idea you fix in any form, I mean to say, the fixation of your idea is a copyright, whatsoever the medium is. So what is the meaning of the fixation? Fixation is when you communicate your idea to the general public, on the very moment an intellectual property right creates, that intellectual property right is in the form of copyright. So, when I am giving that lecture to you, whatever the idea is coming and I am giving to you, or I am communicating whatever coming in my mind, on the very moment, whatever the right created, that right is protected automatically under copyright. This is the finest form of the intellectual property right creation. It may be in any of the form. Whether I write something, then the subject matter is in the literary category. Suppose I sing something in the form of sound recording. If I give in the artistic form or the musical notations, then it will be in the form of artistic category. Suppose I like to have an idea, and that idea I like to form and give a message in the form of any movies or the script, like Dhurandhar. Dhurandhar 2 dekhi sabne? Okay. So whatever the message I like to give you in the form of movies, because the sphere of the concept to deliver my understanding or my creation to the large public, we can take an example of the Harry Potter movie. Limited person has studied the novel of the Harry Potter of the J.K. Rowling, but when it comes in the form of movie, Harry Potter, small kids are also seeing that movie. So the impact of the intellectual property creation and the multiplicity of the rights created, a small idea, maybe in the form of the small literary category. We can have an example of the West Bengal, Kolkata, that song, Kacha Badam song. You must have heard about that song. So, one person has created a meme on that, and that meme is viral all over the world. And look at the remuneration and royalty in that song. People who was selling some badam in the street of West Bengal. So see how the powerful tool of intellectual property right, a copyright plays. We can have the definition of the copyright. What it says, it's a bundle of rights. Why it says a bundle of rights? Because your idea can impact in many forms. Maybe you have written that idea. I took that idea and make a film on that. So there are two rights created, one in the form of literary category, another in the form of cinematograph film. Suppose I write a song, the first idea and the copyright protected under the literary category, then in the form of music category, then sound recording, then in the form of cinematograph film. So a small idea of yours can have a bundle of rights created on a small ideas. You got it? Now it says it's a automatic right, means you need not to go for the registration certificate. It's not compulsory. On the very moment when your idea is communicated to the general public, the right automatically created. When I am delivering a lecture over here, then the copyright subsists to me and it will be valid for the 50 years. So that right is protected under the copyright on the very moment when I communicate that idea to general public. Any doubt on that? Or it is a surf excel, all clear? Okay. On the next point, we can have an exclusive right given to the creator of original work of authorship. May I know that the idea can be copied? Anyone will answer? Whatever the idea is in your mind, can it be copied? No, never. Whatever the creativity comes into your mind, it cannot be copied to somebody else. Okay, so whatever the idea you are having on anything and you communicate that idea, then on the very moment the right of the copyright created. So it says it gives you the exclusive right over it. What it means, the exclusive right? Suppose you are writing some novels. So one right is to protect that literary work, afterward to publish that literary work, or to publish as many copies as you want. That exclusive right gives to you by the copyright. Another point is it allows owner to choose the way in which copyright work are made publicly availability. So suppose I am having some idea, it's up to me how I communicate to the general public. Either in the form of literary work, I just write that thing and make it in the article form, or in the book form, or in the novel form, one thing. Another thing, that idea, I give it to the public in the form of song. Another medium is, whatever the idea comes into my mind, I give it in a shape in the form of source code or object code, means the copyright, the software. Another medium is that I give that creation of my mind in the form of musical notations. Another thing is, or another subject matter or the medium of my creative idea is in the form of song, cinematograph film, etc., or in the form of artistic way, like the painting of Mona Lisa. Understood? Now it allows the owner to prevent unauthorized copying or reproduction. So these things are required to have a copyright on any of your creative work. First, there must be some creativity. Another, that creativity must be in the original form. Another, fixation. However, the term fixation is nowhere defined under the Copyright Act 1957. The fixation is to communicate your idea in any of the form. So these are the 6 categories in which we can have a copyright. One is in the form of literary work, in the form of novel, books, etc., etc. Another is in the artistic work, dramatic work. It is one of the debatable topic as well, whether the Shah Rukh Khan gets the right over the work or over the performance he has made in a film. Anyone will answer on that? Whether the Shah Rukh Khan will get a copyright on the performance he has made in the film? No. So, another is musical work, sound recording and cinematograph film. So, these are the some what we say, who will be the first owner of the work. First, in the case of literary or dramatic work, the original author, the author will be the owner of the work, who is the first author of the work. Another is in the case of musical work, the composer will get the first honor. Artistic work, other than a photograph, in the case of photograph, person who is taking the photograph will be the owner of the work. Any question about this thing? Photograph? No question? तो क्वेश्चन नहीं है तो मुझे क्वेश्चन है. Suppose I took a photo of Aishwarya Rai, then who will get the ownership on that? As per law, copyright law, the person who is taking the photo? Agreed? Let's take a case. What happened? 4 friends gone for a picnic in a jungle. What happened? One of the friend lost his mobile. One chimpanzee came. He took the mobile and tried to eat that mobile. And after that threw that phone. And when they went back to home, then they realized my phone is missing. He lodged a complaint. And after 4 days, he get back his mobile. What he saw in the mobile, some random pictures of chimpanzee. He sent that photo to the National Geographical Channel. It displayed on their website. They rewarded $50,000 to that person. Now the question arises, to whom the picture belongs? Whether chimpanzee who clicked that photo or the person whose mobile is this? This is a valid case. What law says? Now, wildlife authority says, chimpanzee is mine, we give food to them, the picture is ours. So now you say, who will be the owner of that photo? As per law. वो तो चिंपांजी ने खींची थी फोटो. माइक, हाँ.
सर क्योंकि ये जो फोटो क्लिक किया गया था ये चिंपैंजी ने तो किया है, पर हमारा जो स्टैट्यूट्स है, लॉज है, वो ह्यूमंस पे एप्लीकेबल है कि अगर इंटेलेक्चुअल प्रॉपर्टी है तो वो ह्यूमन इनोवेशन से निकलेगा। तो इसको अगर हम लोग देखते हैं, कंसीडर करते हैं, तो इतना भी चिंपैंजी फोटो क्लिक कर लेता है, पर क्योंकि लॉ उसको इनकॉर्पोरेट नहीं करता है, चिंपैंजी को उस डेफिनेशन में इनकॉर्पोरेट नहीं करता है, तो मेरे हिसाब से सर ह्यूमन पे ही वो एप्लीकेबल होगा।
ठीक है, अगर अब लास्ट वाले पॉइंट पे आते हैं, वो बोलता है लिटरेरी, ड्रामेटिक, म्यूजिकल और आर्टिस्टिक वर्क विच इज कंप्यूटर जनरेटेड, द पर्सन हु कॉजेज द वर्क टू बी क्रिएटेड विल बी द ऑनर ऑफ द प्रॉपर्टी। ठीक है, क्रिएट किसी ने भी किया है, लेकिन अगर कंप्यूटर जनरेट जिसने किया उसका राइट होगा उसके ऊपर। तो नाउ द राइट विल बी द अथॉरिटी, forest department, or the person who is having a phone. So this was the debatable topic and decided, very well decided, that the natural person will get the right over the copyrighted work. Okay. So if we talk about our department, what we see, we will ask the no objection certificate of the person whose photo is clicked by the photographer. What we see at the time of giving the registration of the copyright. One more debatable thing is, in the case of cinematograph, film or sound recording, the producer will get the right. This is also one of the debatable topic, because there are many persons involved in making the movies or the film or the sound recording, or in a sound, cinematograph film or something like that. So in that case, only the producer will get the whole right. He will be the author or first creator of the property. Okay. So only the Copyright Act says the difference between the economic right and moral rights. So this is one of the interesting topic here. Suppose I have created something, and even then I have sold my original creative idea to somebody else. Even then one right exists which is called a moral right. Now everybody knows about the term economic right in the financial aspect, but what moral right says, right against distortion and right of recognition. What it says, it is very important right, the right to object to the work being distorted or used in contexts that are prejudicial to the honor and reputation of the author. Another, the author can oppose the distortion of the work in such a way that its cultural or artistic integrity is adversely affected. That is one of the important right enshrined under the Copyright Act. Another one is the right of recognition. Well, even then if you have sold your original right or creative idea, the right of recognition will be yours only. So what is the term for the protection of the copyright is, in the case of published literary, artistic, dramatic or musical work, India is giving more than any country's right, that life of author plus 60 years. If we talk about the other countries, you will find the life of the author plus 50 years. India is giving life of author plus 60 years. In case of cinematograph film is 60 years. Broadcasting reproduction right is 25 years. Performance right is 50 years. Clear? Any question? No question. Good. So what our Copyright Office do, being a government agency, we issue the registration certificate, we give the opinion in the case of infringement matters. The Copyright Office play a key role in protecting the creativity or the creative ideas. Registration ensure the security and recognition of the creator. And a robust copyright system fuels innovation and cultural growth of our country. So these are the function of the Copyright Office. One is registration, publication, advisory and awareness of education in copyright. So what is the benefit for the registration of the copyright? First, it gives the evidentiary value in the courts. Second, it helps to enforce your legal rights. Third, facilitate the assignment, licensing, royalties and commercial use. So these are the international convention. We are having Bern Convention, WIPO and TRIPS agreements. Can we have the next slide? Registration process. Registration process. Next. Yes, just back. Back. So if you want to file the copyright, you will have to fill the form, which is a very easy form. Like when you have, you want to have a Gmail sign up, in the very thing you can have form 14, you can fill the form of form 14. And these are the fees for the copyright registration. 500 for literary, dramatic, artistic and musical work. And in the case of artistic work, which is used for the sale of goods and services, it is for the 2000 rupees, and for the sound recording 2000 and cinematograph film 5000. So this is the process we follow to give the registration. First of all, when we file an application, or the application is received by the Copyright Office, there is a formality check. We see whatever the document we needed at the time of filing your copyright application. Then there is a waiting period. Waiting period means that application goes for the publication for 30 days. If somebody wants to file an opposition or objection for against your application, then he can file. Then the next stage is scrutiny. Scrutiny says the examination. In examination, we see whether your copyrighted work is legible for the registration of the copyright or not. If no discrepancy is observed by the examiner, the application straightaway go for the deputy registrar for the registration of the copyright. And if any discrepancy is found, then the discrepancy letter is issued and you will have to file a reply on that. If your reply is satisfied, then the application goes for the deputy registrar for the registration of the certificates. So, the next slide. No. So, there is also a process how to file your copyright application. What you need is, you will have to log in the Copyright Office. I just want to show you that slide how to file the copyright application. So this is the next PPT, not this one. So, meanwhile, any question about the copyright if you want to ask? Have mic, please. Okay. So this is the registration process which I like to show you. Oh, just wait. This is the prescribed fees, and afterward, this is our Copyright Office website where you will have to create your login ID, same in the form of Gmail ID you create, user ID and password. I'll give you the PPT of that. No need to take up pictures, okay? So, after creating your user ID, you will go to this slide. First, you will have to select whatever the title you want to give onto your copyrighted work, your address, your name, state, PIN code. Actually, it is very important. So you will have to see. Whatever the question you want to put, you can do. After that, your user ID, password and confirm password. Then your user ID will be created. Okay. Yes, you can ask questions.
Thank you. Nowadays, because of the emergence of large language model and artificial intelligence, we are having sort of innumerable creative items available in social media and everywhere else, including images, including texts, including music, including video. Now, I think this would be a pertinent thing to know about the aspects of copyright with those artificial intelligence generated content, and imagine in a particular case, suppose a picture or a music is distorted by artificial intelligence, using artificial intelligence, and a fresh so-called distorted or parody or fake video or music or literature is created. Will it be covered by copyright too? These are my questions.
Thank you for the question, sir. Much expected the same question from the general public as well, especially the new generation who is sitting here. But unfortunately, nobody asked that question. However, if we talk about the another topic is the personality right as well. I really try not to come on that point as well, because it is really a vast topic. If we cover the artificial intelligence, deepfake, personality right, this is entirely a different and debatable topic. However, it is pertinent to mention over here that I have nominated from India, and I have a good chance to represent India in South Korea and the Tokyo, the nominated member from India on the very topic on artificial intelligence. Sir, presently the world is struggling how to have a copyright on especially the content created on the OTT platforms, how to protect the content on the OTT platforms, broadcasters' right, signal piracy, deferred signals, personality rights. However, Delhi High Court has given some verdicts and awarded personality rights to Shri Amitabh Bachchan, I think if I am not wrong, Anil Kapoor, etc. So as far as your question is concerned regarding artificial intelligence is concerned, presently the India has formed a committee where some professors there as from the Delhi University as well regarding artificial intelligence. They have published a paper as well. But if we talk about right now, we are not having, if we talk about India is not having a particular law how to protect artificial intelligence work. No doubt when we were, I was in South Korea when different country was having or passing their views on artificial intelligence, then I found that they have drafted a very good policies, especially the South. If we talk about South Korea, sir, they are having a very well equipped police authority how to deal with the artificial intelligence cases. They are having a separate unit to deal or investigate the content which is uploaded against YouTube or the different platforms. They are having a separate division to check all the contents. All the content means it's a vast content. Even then, they are having such softwares. So, these things, even India is not lagging behind. We are also trying to cope up and words with different platforms how to deal with the artificial intelligence. But even if we talk about Indonesia, lastly, when I heard words, the bill was present for the president assent for the artificial intelligence. And again, I am on that. Presently, we are not having some law how to protect the artificial intelligence. However, no doubt, there is some creativity and it must be a strong structure to give the right on artificial intelligence. Personally, I believe if we talk about the subject matter, this is my personal view. If we talk about the subject matter, it is actually a topic of research as well. If we talk about the subject matter of the copyright, there is a 6 subject matter where you can have a copyright. Okay, literary, dramatic, artistic, cinematography, software and musical notations. We can have, the young students may make a research on that and article. We can have a different subject matter that is not on artificial intelligence, but the computer generative work or generative AI. Because the Copyright Act itself says the original work. One way we are saying, that is my personal view, one way we are saying we are protecting the original ideas or original creation. Another way we are saying and we are talking about artificial intelligence. The term started with the artificial things. But we have given the name artificial intelligence. One way we are talking about original creative ideas. Another way we are talking about the artificial intelligence. We can give another name and create a different subject matter in the form of machine learning or machine generated works. So we are also, our ministry is also working on the amendment of the copyright. We have asked the suggestions from the general public or the stakeholders. So it's good if we find some suggestions or what we say different ideas if you are having regarding artificial intelligence or the computer generated work. Presently we are not having, sir. And what word says, if we talk about the US, if we talk, it's a good to mention here, if we talk about the China, they are having some labeling thing on the artificial intelligence work. Whatever the work you have created from artificial intelligence, you just give the label on that and then you can have some protection on it. And that protection only relating to the human creative work rather than the artificial. However, you can label on that thing, on artificial intelligence related works. So this is my knowledge about that. So actually it's a big discussion. We can have another session on especially on the artificial intelligence. Yes, ma'am.
Good afternoon. I have one question.
It's okay, ma'am.
That,
Very welcome, ma'am.
That whatever we give as our intellectual product, the very moment, how do I, when I am confident about my product, actually I want to know if a human being is a not always self-learned. It is, our learning comes from the environment, from hearing, perception and observation. So how do I understand that my creative learning has given a product from me as a creative product? So that I can give it for copyright. In the text matter, it is easily solved by the uploaded computerized papers and other things. In the other values, musical, drama and all, how do you distinguish it that it is original, it is not taken the others views, ideas and spirits and imbibed in it as partial or complete or half? So that is my question. If I can get the answer from you.
I'll try my level best, ma'am. However, copyright is a very technical subject. And what I learn in my short span of time and working under the copyright registry, what happened, I want to share my first experience when I was dealing with the copyright office as a deputy registrar. I was one of the designated deputy registrar to give the copyright registration. One case came in front of me, the novel Half Girlfriend. So I have already heard about even I have seen the movie Half Girlfriend, and again the work came and novel came with the title Half Girlfriend. So I straightaway discussed with the registrar of copyright. I said, I know about this term Half Girlfriend. I have already read that novel and I've seen the movie. And again, another novel came for the registration. So he told me that whatever you are creating, suppose I am writing something about defamation. If I write some meaning on the defamation, I have learned many things about the defamation. But suppose I am writing the meaning of the defamation and it is not copied by someone else, from someone else, then that idea of mine, that original creative thoughts comes to my mind after hearing many definitions and meaning about defamation. That original idea or creative thoughts, and I write about defamation, that will be the original idea of yours unless it is copied from somebody else. On the very moment when you write that thing and publish, on the very moment you get a right on it. So this is my knowledge about the copyright. As far as the registration point of view is concerned, under the Government of India or the copyright registry, we are not presently, although we are working on it, presently we are not having some softwares or the plagiarism kind of things to judge whether it is your original ideas, original creative things or not. Even it is not possible, I think. Ma'am, I know what's your question is. And it is, I think it's not possible because India is having so much languages. And suppose you give in Tamil and that software converted into Hindi, English or Bengali or some other languages, it's really very hard to have whether that creative thing is copied or your original things. And if we talk about the software is concerned, it's really very hard to run a software. This is the reason that the amendment came and we ask only source code rather than the object code. Nowadays we are having you need to give the source code and not the entire source code. Just 10 pages of front and 10 pages of back. If the source code comprises 50 or 70 pages. So you just give the source code, not the entire source code, and we are issuing the registration certificate. So this is the thing we are doing at the Copyright Office. So I hope and I tried my level best to answer your question. Thank you. So this is a very easy process. You can file your copyright. Maybe in the form, if you create some photos and if you create some songs, if you shoot some videos, okay, you get a copyright on that. Suppose I click a photo, on the very moment I get a right. So how I will file a copyright application? That is very easy process. You just mention the name and address of the applicant, communication address, email ID, then accept. Then the second step, whether it is individual, business or other, name, address, details of the author, then the class of work, whether it is artistic work, literary work, whatever the category you want to select from there. Just write the description of the work, what work relates to, title of the work, language of the work, name and address of the author. If your work is the published work, you just write the published year, or if it is published more than one or in the different nation, you can write. Afterward, who is the owner of the work? And that's it. Now that the statement of further particular, whether it is a translated work or the derivative work or the original work, you just need to mention over here and just pay 500 rupees and your diary number will be generated. What documents you need to submit at the time of filing the application? In the case of literary work, the form 14. If the author is the owner, no certificate required. If the author and owner is different, then you will have to submit the no objection certificate. If the publisher is there, no objection from the publisher. If the application is filed by the attorney, then the power of attorney, otherwise no power of attorney is required. If the application is filed by the company, private limited company, one-man company, then the board resolution of the signatory, otherwise no required. In case of artistic work, this is important because if your artistic work is related to sale and purchase of the goods and services, like Patanjali mark, like Kia mark, like Maruti Suzuki, like Parle, okay? If you are having that kind of label, design or artistic work, in that case, under section 45, you will have to take the no objection certificate from the trademark authority. And if the artistic work is not used for the sale and purchase of the goods and services, then no objection certificate is required, okay? There is one more thing. If your artistic work comprises in a design, suppose you create a design of lehenga, necklace, or some ornament design you make, in that case, you will have to give a affidavit that that your design is not protected under the Design Act, one thing, and your design is not reproduced more than 50 times. Okay? That affidavit you will have to give. In sound recording, you will have to give the no objection certificate from the person who have worked for the sound recording work or cinematograph film. Under the copyright software, if you want to register your copyright software, you just mention first 10 pages and last 10 pages of the source code only, if the source code comprises more than 20 pages. So, this is the thing. Any question?
Sir, my question is, author is given the copyright, okay, for a book. But after publication, if the book is not made available in the market, what author can do?
So there is a right, ma'am. I think you miss that point. That is one case of the moral rights. Right against the distortion of your work. Suppose you have sold your right to somebody else to publish my book, and he fails to publish your book for 5 years, 7 years, and you see that your work is distorted, then you have a right to publish your own work. Okay? This is the right of, says moral rights.
I can publish it anywhere else.
Anywhere
The
else.
author can,
And you can write a letter to the copyright registry that so and so thing happened to me, my work, and now I want to publish my work. So accordingly after that you can publish, no problem in that.
Thank you, sir.
Even then you have taken that money from that publisher. Even then that moral right will subsist you.
Sir, for literary works, it is 60 years after the author has passed away.
Right.
That means after 60 years, the work comes in the public domain?
No, it's not like that. It's very much clear that after the life of the author or the owner of the property, that 60 years will subsist. Okay?
So that means after 60 years, if
It will be in the public.
Yeah.
Same in the case of patent.
Yes.
If we talk about the patent, that is only for the 20 years, then it goes, that invention goes for the public benefit to use that formula. We can take an example of the paracetamol. Okay? Whoever have invented that formula of paracetamol, then it can be used by anyone else after 20 years in the case of patent. Same way in the case of copyright.
So that means after 60 years, can the author's family claim copyright in any case?
Not after 60 years.
Okay.
After the life of the author, 60 years will subsist that right to the family or the legal guardian of that owner. But after that, that right goes to the public.
Okay.
Okay?
Thank you, sir.
हेलो सर, मेरे दो क्वेश्चंस हैं। पहला क्वेश्चन है कि आईपीआर में मैं थोड़ा सा और बहुत कुछ जानना चाहता हूँ, जैसे पेटेंट हो गया, कॉपीराइट, ट्रेडमार्क हो गया, इंडस्ट्रियल डिज़ाइन हो गया, जीआई हो गया, ट्रेड सीक्रेट हो गया, एंड स्पेशली पेटेंट्स रिगार्डिंग द मेडिकल इक्विपमेंट। और मेरा दूसरा क्वेश्चन ये है कि हम लोग जो देखते हैं ऐसे मार्केट में सेकेंड कॉपी प्रोडक्ट बिकते हैं, फर्स्ट कॉपी प्रोडक्ट बिकते हैं, तो इस पर कोई रेगुलेशन है या नहीं?
है ना, वो आप इन्फ्रिंजमेंट में केस फाइल कर सकते हैं ना उसमें. You have a right to file a case for the infringement as well. And you skip one more topic in the intellectual property right, which is also one of the debatable thing which is TKDL, traditional knowledge, add that point as well. But because of the short span of time, it's very hard to define all the intellectual property right here. So, ma'am can have a different lecture on intellectual property right in the different fields, patent, copyright, design, etc., etc. So, because it's a very vast terms, if we talk about GIs, it's a different subject. We talk about the patents, and the trademarks, etc. Patent is, sir is going to enlighten you. As far as the trademark is, it is for the sale and sale of goods and services. Whatever the mark you have created, one is a smell mark as well. There is a two kind of marks. One is conventional and another is non-conventional. Conventional is whatever the figurative marks, whatever the mark like in the words, logos, device, smell, moving, 3D images. So whatever the mark you are using to sell the goods or services is a trademark. Okay. And GI is, suppose some environmental factor includes what indicates about the production of the goods. If we talk about the Darjeeling tea, basmati rice, Kashmiri saffron, what aroma comes like in Darjeeling tea. So whatever the climatical condition is there to have that product gives a geographical indication tag on it. That is GI. So in that time I can tell you only that.
So one more thing that is related to patent. That
So sir is going to have. Okay, thank you. Any question? Thank you.
Hello, hello.
Yes.
Hello, sir. My question is, as you have already explained that the protection of a AI-generated work is quite gray area at this moment in India. Now my question is, if we follow the DB Modak verdict by the Supreme Court of India, where it says to have a protection on a certain work, you have to show a modicum of creativity. That is the American standard. So the thing is, if I use AI-generated content partially and make a work of compilation, what protection may I get in terms of the copyright statute on that protection or on that work?
Thank you for the question. Actually, presently, again, on the same thing, presently we are not, if we talk about the Copyright Office, Indian Copyright Office, we are not issuing any registration certificate on any form of AI generated works, whether in the form of author, co-author, etc., etc. However, if we talk about the earlier registration, it was done by me. I was the deputy registrar at that time when I give the authorship, ownership on the Suryast work. So actually I was very new at that time. I saw that application. I awarded the registration on that as a co-author. But after having words with the ministry, Government of India, that work, AI generated work, Suryast, is withdrawn, and that is the stake, and that is the presently we are working. We are not giving any ownership and registration on the AI generated works. However, if we talk about the China, as I have already mentioned, they are saying that there is some label whatever the AI generated work you are having, that label you will have to mark on that, and whatever the human interference or human creativity is involves in that AI generated work, you can have the copyright on the human interference or human creative things. Okay, thank you for the question.
Sir, I actually have a follow-up question. As you have mentioned the Chinese reference, so I was reading one verdict of the Beijing Internet Court, the Li versus Liu verdict. So in that case, they said AI is used to generate a certain report or blog. So human was there, he was dictating the prompts.
No, not in that case.
I guess that is the Xianjian Tencent.
Not in that case. If you use the chat GPT and create something, only saying and giving the instruction does not create the original work, I think. This is my personal thing. Thank you.
Thank you, sir.
Thank you. Thank you.
Thank you so much, sir, for that truly enlightening and enriching session. We are deeply grateful to you for sharing your invaluable knowledge, vast experience, and practical insights with us. Your address has not only enhanced our understanding of intellectual property, but also inspired us to look at innovation with greater awareness and responsibility. It has indeed been a privilege to listen to you. May we all put our hands together for a warm round of applause for Dr. Hemant Koshla once again. Building upon this insightful deliberations, we now move forward to our next session, where we will continue to explore the dynamic dimensions of intellectual property. Before introducing the next guest speaker, I would like to make an important announcement for the participants. The participants, those who will attend the workshop till end, will only get the certificates. Otherwise, certificates will not be provided, because this workshop has been organized for all of you, and we want you all to attend the workshop till end. Then only you will get the total conclusion of this workshop, because the legal aspects will be discussed in session 2. It's really important for you to understand the whole concept. So once again, I would like to request each and every one of you to attend the workshop till the end. Until we conclude the session 2, we won't be able to provide certificates for the participants, those who will not attend the session till end. So now it's my privilege to introduce our next speaker, Sri Shantanu De. Sir is currently serving as the Joint Controller of Patents and Designs at the Patent Office, Kolkata, under the Ministry of Commerce and Industry, Government of India, and has been associated with the Patents Office since 2002. He holds a bachelor degree in mechanical engineering along with an MBA, bringing together strong technical and managerial expertise. Sri Shantanu De has also gained valuable international exposure through his participation in prestigious seminars, including the European Patent Academy Seminar on Search and Examination Methods held at the Hague, Netherlands, and Munich, Germany in 2007. And also the IP Executive Week held in Alicante, Spain in 2017. In addition, he has acquired knowledge in foreign languages, including certification in Spanish. Prior to joining the Patent Office, Sir also served in the Ministry of Defense, Government of India. Sir, with such rich experience and expertise, we are truly honored to have with you us today. May I now request you to kindly deliver your lecture and share your valuable insights with us. The stage is yours, sirs. Thank you.
Good afternoon, everybody. And it's a pleasure for me for coming here and participated as a speaker. And it's a really pleasure for me. And let me introduce first, I am Shantanu De from Patent Office, Calcutta, working as a joint controller of patents and design. I am working in the mechanical group. So, you know that Patent Office belongs to 4 groups only, that is mechanical engineering, electrical or electronics engineering, chemical and biotech. So this belongs to, Patent Office belongs to invention only. So my topic is basic idea converted to tangible or intangible product. And I am touching all the IPRs in a nutshell. Whatever Dr. Khosla told about the copyright, I just tell briefly about the copyright also. But basically I am from Patent Office, Calcutta. So my subject of interest and question of interest belongs to patent only. And so before starting the IPR, so you know there are separate category in different fields. One is patent, number 2 is design, then trademark, geographical indication, copyright and semiconductor integrated circuit layout design. Okay. So first of all I am telling that this is IP right, intellectual property right. It is intangible property. Why it is intangible property? Because it comes from our intellect. And it's not like our any tangible property like building, cars, etc. But for both the cases, we have to register. Otherwise, it will be stolen, it will be copied. So it is the importance to protect our idea in the intangible property right, that is IP right. And I am telling that from the very beginning of morning, we are using IP right. That is IP in everywhere. In the morning when we are waking up, just use toothbrushing. That is, we are using toothbrush. That is the technical aspect of the toothbrush that belongs to patent right. And then if it is shape, particular shape of the toothbrush, then it is registered by design. So what is the difference between patent right and design right? That is, design right is solely judged by our eyes. But for patent right, it is the technical aspect involves in the toothbrush. Whenever we are using the toothpaste, that is the chemical composition of the toothpaste, that is belongs to patent right. And then it is the specific shape of the toothpaste, that is belongs to design right. And there is a specific symbol of the company, then it belongs to trademark. And then again we are approaching to read the newspaper, that belongs to a particular right, that is copyright. And then we consume Darjeeling tea, that is a specific attribute of tea of the particular region, that is protected under Darjeeling tea, and that is called geographical indication. And then we are using the mobile gadget, that is integrated circuit in the mobile, that is under semiconductor integrated circuit layout design. So there are the integration of all the subjects, but there is some difference. Now I am showing different IP in a single product, that is laptop. Laptop is a specific shape which is registered under design, and the technical configuration or technical aspect, that is LED display, it is protected under patent. Then the sign of Apple, it is protected under trademark, and user manual, that is protected under copyright, and integrated circuit, that is protected under SICLD. Now the intellectual property right, that is resource, brain and labor, and by which the intellectual property is developed, it is called intellectual property right. And why we have to protect the right? Because if it is not protected, it may be stolen, and then the right is not belongs to you, belongs to others. So you have to protect your right. And to exclude others. Why to exclude others? Because after getting the particular right, you can enjoy this benefit for a particular period and to exclude others, because if it is copied by others, then you can sue before the court of law and utilize the commercial earn. Utilize the commercial earn, whatever in the morning our VCs are told that not to apply for patent but to apply in a specific product, and that is to be applied for commercial earning, and that is to be developed for our country. For that reason it is called commercialization. Utilization and commercialization, that is for own use, that is for license or assign, and that is for franchisee, and that is for merchandise or something else. So it is used for own use also, and it is used for commercial purpose also. Common man, that is common man. What is the objective of the common man? That is to pride and academics. And commercialization, it is the objective of the businessman, to brand value and earn and invest. Now the patent right. I already told that the patent right belongs to any sort of invention. So if it is an invention and you know the invention, then you can apply for the patent. Whatever VCs are told in the morning, that if you are working on behalf of the Calcutta University, then you can apply for the patent on behalf of the Calcutta University also. So it is the brand value of University of Calcutta improved. So now there is a question, that is applicant and inventor. Who invent the product? He or she the inventor. But who is applying for the patent? He is the patent applicant. So patent right is given to the applicant only. So if inventor is applying, then inventor is the patentee, and if Calcutta University is applying, then Calcutta University is the patentee. Patent right is a statutory right and invention granted for a limited period of time, that is for only for 20 years from the date of filing. Legal right to exclude others, no concept of global patent, and tenure of patent is 20 years. So there is a question, we are used to tell about the global patent, but actually there is no global patent. Patent right is given for the territory only. That is, if you are applying for patent in India, that is not covered in USA. You have to apply in the US patent office also to get the protection. Famous inventor and the first patent is, that is Pankha pulling machine, George Alfred Depenning, 1856. And there are so many inventions, you know all this. There is a famous invention and also very small invention, that is the stamp with the LED. Whenever it is broken, the light will be glown. So, by this example, you know, if the invention is small, that is also not to be ignored. That can be also protected under the patent right. Again, nano car, hepatitis vaccine, and Jaipur food, all are affordable price, and those are inventions. Again, very small example, that is to protect the child's head, and there is a mobile display on the hand. There is a device for debit card, credit card, there are drones. So all are involved with the technical aspect. So all that belongs to patent right only. Patent application filing. Want to file patent application in India, what to do? What form should I fill? How much is the fees? There is form 1, there is form 2. Form 1 is the details of applications. Fees need to be paid for form 1. And there is a form 2, there is form 3, that is whenever you are filing in India and also filing in other country, then that declaration is to be given also. Form 5, that is declaration as to inventorship. And form 18, that is request for examination. That fee is also to be given. Now, whatever as far as copyright is concerned, in the morning, one person asked about the AI related invention. Now the question is, who is the inventor? If we are thinking about the form 5, that is declaration as to inventorship. If there is a AI related invention, then who is the inventor? It is my question. Because who is giving the software programming, he may also be the inventor, or otherwise the applicant is claiming some other inventor. So he may be also the inventor. So how can it be settled? Next, in the course of action I am telling. It's a burning topic and it's very difficult to answer also. Now form 2, that is details of invention, belongs to title, description of invention, particulars of drawing, brief description of drawing, brief description of the invention, claim, abstract, drawing. So in this case, the drafting of the specification is very much important. Why it is so much important? Because we generally traverse in our day-to-day work the drafting of one inventor. If he or she is not going through any patent attorney, then he does not know how to draft the patent specification, and very difficult for him and very difficult for us. Because very difficult for us, what is the invention? And very difficult for him because whenever he is giving the patent right, he is losing something. Because the invention is not clearly specified in the specification. So drafting is so much important. So for you people, whenever you are going to apply for patent, the drafting of specification very much useful. That should be fully disclosed in the complete specification. Otherwise, you are losing your patent right, losing your inventorship. Now the question is, before that you are the inventor and you are thinking that your invention may be copied. So what to do? First to apply for patent. And now you are thinking, no, it is now you are apprehending that it may be copied at the very moment. So what to do? You can apply with the request for early publication to acquire the provisional right. For you people, I am telling, whenever there is an apprehension that the application or invention may be copied or going to copied. So not only to apply for patent, but also to apply for request for early publication, because by publication you are getting the provisional protection. That is, you are recognized as an inventor in terms of publication in the patent office. Now what is the fees? You just think that if you are an individual, the total fees will be 5600, which exclude the renewal fee, I am telling. Only the filing fees, basic filing fees. And if you have a company, then the basic filing fees is 28,000. Filing procedure, that is submission, hard copy or through the soft copy. For soft copy, you have the digital, you have to acquire the digital signature, and then you have to create the user ID and password, and then you have to upload the PDF file. Expedited examination. What is expedited examination? That is a separate route. That is for you only. That is a separate route that is examined in the specific route. Whenever it is under expedited examination, it is not going through the normal route. It is expedited. Who are eligible? That is startup, small entity, applicant is a female for joint applicant, department of the government, India has a ISA IPA, an agreement between the Indian Patent Office and Foreign Patent Office, and the applicant is a institution wholly or substantially financed by government. So in that case you know everything, but the thing is that ISA IPA under PCT. What is ISA IPA? That is a search authority. Search authority, whenever, suppose you are able to find out your invention is actual invention or not. You are thinking it is an invention, but it may not be an invention. So you may apply through PCT, that is a search authority. And whenever you are selecting ISA at India, that is searched first, and then you can get the search report followed by examination report. And after the search report and the examination report, you can find out that it is actually invention or not. So based upon that, you can proceed or you can withdraw your application. Patent application processing. That is patent application, there are different types, that is ordinary, convention, PCT. Ordinary application, that is provisional application and complete specification. What is provisional and what is complete? That is, if your invention is not completed, but you want to get the date of application, then you can apply the provisional application followed by complete specification within 1 year. But you have to file within 1 year, otherwise it is treated as abandoned. Then it is published. Then after publication, after the request for examination, it will be examined. Then the response to first examination report. Then if there is no objection, it is straightway gone for grant, otherwise a hearing is to be offered. Now screening classification. All the patent application is screened and classification. Why it is screened and classification? First of all, it is screened and classification for our purpose. So to understand the invention belongs to which subject and belongs to which group. I already told that there are 4 groups. So screening classification is required, and other aspect of the screening classification is, if it is belongs to defense, then we have to approve from Ministry of Defense. And also if it belongs to atomic energy, then we have to approve from Department of Atomic Energy. Now the question is, why the publication is required? Publication is required for technological dissemination and also opposition. Whatever in the morning the question asked about the AI related invention. So if it is belongs to AI related invention, then who oppose? The person interested will oppose after seeing the publication. So it can be settled in the pre-grant opposition or post-grant opposition. Pre-grant opposition means that is before the grant of patent, and post-grant opposition means after the grant of patent within 1 year. Examinations belong to formal and technical. Gist of objections, check, reply, re-examine, remove the objection, and the technical discussion, pending objections between application and hearing, and then grant or refusal. So whatever I am telling about the new, that invention is new, then we have to check whether the invention is new or not, and that is to be established globally. That is, we have to check globally whether it is actual invention or not. Technical examinations, read and understand, then search for related invention. Whatever I told already, that is global invention. That is, whether it is new or not, it is to be established by our examiner of the patent office. Then check for novelty and inventive step. Now novelty we know everything, everybody, but inventive step, why, what is inventive step? Because one person is thinking that he is creating one invention by combining 2 or 3 documents. But our patent office will examine that is to be done or not. If it is done by the teaching of 2 to 3 documents, then our patent office object under section 21J, that is, invention is not an invention, it is falls under inventive step. That is obvious for a person skilled in the art. After the teaching of the 2 to 3 documents, it is obvious. Now the provisional to complete specification I already told, that is 12 months. Request for examination, that is 48 months. Reply to FER, that is 6 months, extendable by 3 months. Form 3, that is 3 months, 6 months. Form 5, that is 1 month. Withdrawal of application, that is 15 months. Hearing submission within 15 days. Pre-grant opposition before the grant of patent and the post-grant opposition after 1 year from the date of grant. Now, the separate chapter, that is design. When the particular shape of the product is to be registered and there is no question of technical aspect of the product, then it is to be registered under patent. It is different. So there is a linkage between patent and design. Similarly, there is a linkage between patent and copyright also, because there is no question of software patent. Software as such is not protected under patent. It is protected under copyright. That is language, that is programming. That is as such protected under copyright. It is not protected under patent. But application of software technical effect, that is to be covered under patent right. Design Act 2000, Design Rule 2001, and design means only the feature, shape, configuration, pattern, ornament of compositions, lines or colors that is applied to an article, whether 2-dimensional or 3-dimensional, in both forms, and by any industrial process, by means whatever manual, mechanical or chemical, that is the technical aspect. Technical aspect is not involved in design, but it is solely judged by the eye only. That is particular shape of a product, that is to be registered under design only. Any mode of principle of construction or anything which is a substance, a mere mechanical device and does not include any trade name defined under clause. So there is a, again there is a distinction between the patent and also design and also the trademark. That is, if there is symbol is there that cannot be registered under design, that is to be registered under the design only. If symbol is there, that is to be registered under trademark only. Term of design is 10 years, extendable by 15 years. That is 5 years. Now definition of article, that is section 2A. Article means any article of manufacturing or any substance, artificial or partly, natural, and includes any part of article capable of being made and sold separately. That is important. That is being made and sold separately. Otherwise, the article cannot be registered under design. Now section 2G, in relation to a design means originating from the author, such design and includes the case which thought old in themselves yet are new in their application. Because I am telling the example of any cup dish. Cup dish is very old, but the specific design above the cup and dish is not old, is unique. That is to be registered under design. There are example of the design article. There are the crockery set, jewelries. Again the filing of design application, that is Delhi, Mumbai, Kolkata and Chennai. And it can be filed online and offline also. Again the application fee is 1000. Form 1, that is applicant's full name, nationality, etc. 2 sets of representation sheets are required. Power of attorney, assignment document, Form 24 if it belongs to small entity or something else. Now there is an assignment document, what I am telling, because there is an applicant and there is an inventor. If applicant and inventor is the same, then the assignment is not required. Otherwise, there is an assignment between applicant and inventor. For instance, inventor of Calcutta University and the Calcutta University. There is an assignment which is required. The specimen of the design representation sheet, perspective view, and here it is mentioned the novelty resides in the shape and configuration, and no claim is made by virtue of the registration in respect of any mechanical or other action. That is, a technical aspect is not involved, which is under the patent right only. No claim is made by the registration to write exclusion use of the word letters. That is, word letter is there, then it is the subject matter of trademark only. There is a linkage between patent, design and trademark. Sample of design's registration certificate, and it is published when there is no objection, when it was registered, then it was published in our journal publication. Showing IP is protected when registered REGD or RD, then it is already registered. Important timeline for ordinary application. Reply to first examination report, that is 6 months, extendable to 3 months. Term of design is 10 years, extendable by 5 years. Now the question of any symbol is there, then that is to be registered under trademarks only, not copyright. Concept: a trademark is any word, name, symbol or device identifies and distinguished the source, good or service of one trader from those to others. Function importance: provide the exclusive monopoly over a class of goods, service, allows the business entity to build the public goodwill and brand, identifies the source, origin of goods or service, assures the customers about the quality. So why the trademark is required? Because by the trade name, general customers have the confidence about the product only. So trademark is necessary. That is trade name, trademarks, collective marks, tagline, slogan, shapes and sound marks. All are belongs to trademarks only. A good trademark is distinctive and not deceptively similar. That is, suppose there is an Arsenal biryani and again the new Arsenal biryani. So it is deceptively similar. That is not to be registered. That is, when the trademark has been given, it is under R, otherwise it is TM. How to protect the trademark? Trademark registration is optional. However, registration has certain advantages. Registration available in the national and regional phase. Dr. Khosla already told about the trademarks. I don't want to repeat. And copyright also, already I told you that there is a linkage between patent and copyright. That is software, if there is a software that is to be protected under copyright, that is not protected under patent. Application of software in terms of a device, in terms of improved technical effect of the device, then it is under the patent right. Otherwise, software as such is protected under copyright. Dr. Khosla already told about copyright, so I don't want to repeat again. That the lifetime, whatever one person asked about what is the duration of the copyright, that is 60 years after the death of the author, and then it is under public domain. And there are different copyrights, that is literary work, artistic work, dramatic work, musical work, sound recording, cinematography work. And everything already I think Dr. Khosla told. Dr. Khosla told about copyright, economic right, moral right. That is, moral right is non-transferable, economic right is transferable right. And then there is economic right. It is once again, it was told by Dr. Khosla. And right against distortion, right of recognition, it is also told. Application procedure, it is also told. And what are the fees? Now the SICLD, that is Semiconductor Integrated Circuit Layout Design. Again I am telling that it is a linkage between the patent and the SICLD. Whenever there is an integrated circuit that cannot be separated, then that integrated circuit cannot be registered under patent. There is a separate chapter and it is protected under SICLD. Semiconductor integrated circuit means product having transistors and other circuitry elements inseparably formed on or inside a semiconductor. Insulating material designed to perform an electronic circuitry function. Layout design means layout of transistor and other circuitry elements. Semiconductor integrated circuit layout design is in Delhi only. SICLD is an important IPR, and the registration of a layout design is a period of for 10 years from the date of application of filing or first commercial exploitation, whichever is earlier. Now there are the flow chart of the SICLD and there are the fees of SICLD. Now the GI. Last IP chapter is geographical indication, that is Darjeeling tea, Makrana marble. So everything is attributed to a particular region, and that quality is ensured by the specific IPR chapter is called geographical indication. Now the validity, that is patents, it is 20 years, after that it is under public domain. Design 10 years, extendable by 5 years. Trademark indefinitely, subject to renewal. GI also indefinitely, subject to renewal. And copyright published, literary dramatic work. And who can apply? Any person can apply except the GI. For GI, the partnership, small entity and a body corporate can apply. The points to be remembered, that is first protect and then publish. Rights are territorial in nature. Registration is done by the sovereign authority, that is Government of India. Rights for limited period of time. No automatic relief, that is you have to sue before the court of law. Renewal fee is required to be paid. Appointment of patent attorney is not mandatory, it is optional. Career opportunity for patent office, you can, it is a government job, examiner of patents and designs, examiner of trademarks and GI, and others, that is patent attorney, trademark agent, JRF, SRF, etc. For further details, you can approach to our training office, that is RGNIIPM, Nagpur. Thank you. And any question, please ask. So in the morning, there is a question of patent, I think. So you can ask the question.
Hello, sir. I have actually two questions. First question, why are patent right limited to the individual countries, and even though international agreements are there existing? Explain the legal economic policies reason, for what reason that the single trademark umbrella law is not there, and if any suggestion is there, please enlighten us. And my second question is related to the patent actually. How does effective coordination and the implementation of IPR influence the availability and the affordability of medicines and medical devices at the grassroots level? What step government should initiate, and what are the challenges in maintaining and enforcing the IPR rule in healthcare system are there in the public health sector?
As far as the first question is concerned, if you are going through, that is a technical right and the world patent. So if there is a, that is global patent, then there is only one patent office in the world. There is no question of Indian patent office, US patent office, nothing else.
But there should be some offices in every, like there are embassies in every country.
And also the thing is that there are the separate legal provisions for different countries. Legal provisions are not the same for different countries. Legal provision is different. For that reason, we have to apply separately. And as far as the legal application, legal acts and rules are concerned, we have to follow for the particular country only. It is not applicable that Indian patent is applicable to US patent. It is not like that. there is no global statutory provision. There is Indian Patent Act, there is US Patent Act, there is EP Patent Act, something else. And second question is that is whatever you are asking about the medical device, it is registered, it's not a problem under patent right, but you have to work with that. Otherwise, suppose that some medicine is very much important for us, that is to be available, that is to be at the price level should be affordable by the common public. There is a separate provision under compulsory licensing. So it's not a problem, I think so.
But the medical devices are very much expensive. যদি আমরা দেখি স্যার যে কোনো আমাদের হসপিটাল ইকুইপমেন্টের প্রাইস অনেক বেশি হয় অ্যান্ড ফর দ্যাট রিজন সাধারণ মানুষের চিকিৎসা করাতে অনেক সময় প্রাইভেটে যেতে হয় তো এটার জন্য স্যার গভর্নমেন্টের কিছু পলিসিস অ্যান্ড থিঙ্ক ট্যাঙ্কদেরকে ভাবা উচিত না
Basically, whenever you are thinking that it is indigenous product or it is not indigenous product. If it is indigenous product that is to be registered in India, then I think it is not so much costly. But if it is foreign product that is to be protected under their law, then automatically the price increases. There is no question of regulation of this matter.
Thank you, sir.
So any other question? Yes. Yes.
Patent application, then in that case, can I get copyright protection for that particular style of writing?
Again, there is a question of copyright protection and the patent protection. Whatever I told, there is a linkage between patent and copyright. If you are a software, then it is under the copyright only. And then again, the application of software resulting in improved technical effect for a particular device or systems, whatever may be. Software application in the automobile industry or anything else, then it is under patent. And whenever you are telling about the patent drafting, you have to establish whether it is new or not, then it is under copyright. Everything, for everything it is to be new and your creation is required. Otherwise, it is not protected under any IPR. Clear?
Thank you.
So, any question?
Hello, sir.
Yeah.
What type of performance are included in performance rights? And second question is, suppose two scientists are working on a research, they have more or less equal contribution, but later on, due to some dispute, they become rivals of each other, then who will get the patent? Who can file it? Explain the procedure.
As far as the performance is concerned, that is, I think it is under copyright only. Under copyright only.
What type of performance are they? Can you enlighten us?
That is suppose a program is performed by a particular person, then it is a performance right, and that is to be permission is required from the original creator.
Like artistic performance?
Artistic
theatrical
performance.
Okay.
It is Dr. Khosla's chapter.
And my second question?
Second question, please repeat.
Suppose two scientists
Yes. Two scientists are working in a particular laboratory and they have applied for a patent, okay?
No, they work together, they have equal contributions.
Yeah.
But at a later stage, due to some dispute, they become rivals of each other and they want to file the patent on their own name, not jointly. Can it be possible?
That is, they have not applied for patent previously.
Yes.
Okay.
They
And
are working.
after the rivalry, they are applying for patent separately.
Yes, yes.
So there is a question of opposition. Whatever I told already, that is opposition is two types, that is pre-grant opposition and post-grant opposition. And that is after publication, suppose Mr. A have applied for patent, but there is a contribution from the side of the Mr. B. But Mr. B comes to know after the publication Mr. A applied for patent. Okay? So Mr. B, what is the function of Mr. B? He goes for pre-grant opposition of the patent or post-grant opposition of the patent.
Then how the patent will be given?
Because you have to establish, that is Mr. A or Mr. B has to establish who is the original inventor. It is not the responsibility of the patent office, it is the responsibility of Mr. A or Mr. B.
Okay, thank you, sir.
Yes.
So suppose in a country, some company made a technology and they patented that in that country and they forgot to patent it in India. They have patented in other countries and they have not patented it in India. So in that case, suppose a company in India makes a same or similar technology, then will that foreign company be able to file any case against the Indian company?
Basically, the thing is that whatever I told already, that is, it is a right belongs to the specific country only. So he or she applies for other country rather than the India, then he enjoyed the monopoly right except India. So he is losing that right. For that reason, entrepreneur or individual has to think about that, where he has to apply for patent, where he is getting the commercialization for patent. For that reason, every applicant wants to apply for his country and other countries. Whatever he or one person is asking that his global patent, there is no question of global patent. That is territorial right. That is you have to protect. That is I am an inventor. I want to do the business in China. So I have to protect my invention in China also. It's territorial right.
Thank you, sir.
Welcome. Any question?
To ask a basic question,
Yeah.
I don't have the idea, so I am asking. Is there any relation between citizenship and applying for protection of my invention? Like I am an Indian citizen, I have invented something, then I am applying for US patent or copyright. So,
If you are the, suppose you are the citizenship in India,
Yes.
and you have directly apply for USA,
Yes, is
then
it
there is
possible?
it is possible, and then you have to apply under section 39, and you have to get the permission from patent office. So my question is still unanswered, that is AI related invention. Whoever is asking in the copyright, my question is again to you people, who is the inventor for AI related invention? It's the burning topic. It's my question to you. Whatever asked in the copyright session, I am asking that question. Whatever may be, apart from that, if you have any question, please ask.
Sir, I think logically that AI problem you are telling, both the person who is prompting the AI to do some work or something, he is also a co-inventor, and the AI company can also claim some co-inventorship, isn't it?
But the thing is that whenever there is a software, there is no human, that is software is doing something. Software is doing something, na? So who is the inventor?
The software company.
Software programmer.
The company.
Programmer or company. But the software itself is not the inventor.
But the software is designed by the software company.
It's
so
the answer. Actually, it's the answer.
means
Because the human brain of the particular thing, that is to be awarded by the inventorship. But it is a burning topic. As far as my knowledge is concerned, it is my answer.
So both the AI company and the person who is prompting, both are co-inventors, isn't it?
No, I am telling that is the human brain. Whatever may be, you are telling the a person or the company, whatever may be, the
It's
human
the AI
brain,
user.
AI user, whatever may be, that is to be the inventor.
So AI company will not be, cannot claim the inventorship.
I am telling again that is the, it depends upon the patentee, depends upon the patentee who is applying for patent and who is the inventor. There is a distinction between applicant and the inventor. I already told about the applicant and the inventor. That is Calcutta University is the applicant and the scholar is the inventor.
Yes.
Whatever our VCs are told in the morning.
Okay, sir.
Any question? Thank you very much.
Thank you so much, sir, for that insightful and engaging session. We truly appreciate the valuable knowledge and practical perspectives you have shared with us today. It has been a privilege to listen to you. Now, we are happy to have the presence of two guest speakers among us. Dr. Moa Hom Chaudhary, Scientist C and Nodal Officer, Patent Information Center, WBSCST, DSTBT Government of West Bengal. I would like to request ma'am to come to the dais and take her seat. We also have among us Advocate Anjan Sen, another guest speaker for today's workshop. I would also like to request sir to come to the dais and take his seat, please. Along with them, I would also like to request Professor Shobhuj Kumar Chaudhary, the coordinator of IPR cell, to come to the dais and take his seat, please. Before moving to the next session, I would like to request Professor Shobhuj Kumar Chaudhary to felicitate our guest speaker, Dr. Moa Hom Chaudhary. Please give a round of applause for ma'am. I would again like to request Professor Shobhaj Kumar Chaudhary to felicitate another guest speaker for today's workshop, Advocate Anjan Sen. Again, an important announcement for the participants. Let me remind you all, those participants will only get the certificates, those who will stay till the end of the session. So, participation certificate means you have to participate throughout the workshop. So, it's a request to all of you to stay till end and learn from this workshop. Please give a round of applause for Advocate Anjan Sen. Let us now introduce our next guest speaker. It's my privilege to introduce our next speaker, Dr. Mohua Hom Chaudhary. Ma'am is a senior scientist and nodal officer at the Patent Information Center under the West Bengal State Council of Science and Technology, Government of West Bengal. With over 25 years of extensive experience in intellectual property rights, she has played a pivotal role in strengthening the innovation ecosystem through patent facilitation, geographical indication registration, technology transfer, and capacity building. Academically, ma'am holds a degree in chemistry from the University of Calcutta, along with a BTech and integrated PhD in biochemical engineering from Jadavpur University. She is a registered patent and trademark attorney and has made remarkable contributions, including facilitating 400 plus patent filings and securing 140 plus granted patents, coordinating 1000 plus patentability assessments. She also led over 60 geographical indications projects, including 43 GI filings and 31 GI registrations, featuring renowned products such as Sundarban honey and Bangla Roshogulla, facilitated more than 1139 GI authorized user registrations. Ma'am has also contributed to the protection of 24 rice varieties under plant variety protection. In addition to her extensive field experience, ma'am has made significant academic and innovation-driven contributions. She has authored 20 books and brochures along with multiple book chapters and has published over 55 research papers in reputed journals. She also holds Indian patents based on her original research. She has played a key role in capacity building and innovation promotion, including introducing a postgraduate diploma in IPR and technology business management and mentoring 80 plus grassroots innovation and startups, supporting technology transfer and entrepreneurship and development. Her remarkable contributions have been recognized through several prestigious honors, including the National IP Award 2024, the Excellence in IPR Support and Filing Award, and the Women Achievers Award, among others. It's really an immense honor to have Dr. Mohua Hom Chaudhary with us. I would like to request ma'am to come to the dais and deliver the lecture. So we begin with the next session. The stage is yours, ma'am. Thank you so much.
Slide changer is here?
Yes, slide pointer is here.
can change from here? Thank you. I take this opportunity to thank you, Professor Shobut sir, for inviting me in this occasion. And you know, this intellectual property rights sale is actually, it is the initiatives of Department of Science and Technology when in the 2020 to 23, we have collaborated with this university and initiated to form IPO cell, which is now a bigger positions, and this workshop is going on every year. And with this cell, we have set up 45 IPO cell throughout West Bengal to sensitize and to inspire all academicians, scientists, students to file more and more patents because as per Global Innovation Index, where our position is in 38th position, but West Bengal is now 13th position in filing, in patent filing, where before COVID it was in 8th position. So our position is down nowadays. So to improve and to being in the top 5, we need to know what intellectual property right is. Before going to the core of my discussion, I want to mention two important points that was discussed in the previous session. That first point was that whether if there is any big medical company who is not actually able to, particularly that is the cost of the product is high, so how for this as a Indian, how we could get the effect of that patented medicine. That provision is also there. One important provision, that is compulsory licensing for anyone who is interested to commercialize that product, that is possible through compulsory licensing. And another important thing is that, another question I think there was, that if someone filed in other country, and if they want to get that someone is using in India, but they have skipped the India, in that case, when you are going for filing any patent, you can file PCT also, Patent Cooperation Treaty, so that you can get the protection and you can enter into different countries within 31 months, who is the signatory member of that Patent Cooperation Treaty. So these two important factors I want to communicate as actually we are the nodal agency of Department of Science and Technology and Biotechnology of the state for filing protection of all intellectual property rights of the state. So these two important issues I want to mention. I just mentioned in the beginning. I try to cover up all the issues very first. Already you have got the knowledge about different aspects of intellectual property rights, but when you are going for filing patents, you need to go in the problem solution approach. That means there is a 7th stage from idea to assets, as it is the name of the workshop. What is your idea to product launch? It is basically 7-stage process. So you need to have some workable idea, but whether this idea is patentable, whether it can be commercialized, you do not know. So your idea need to be screened, whether the same idea already patented or not. So afterwards, concept development and strategy formulation. So whether you will file this patent or not, that is another important roadmap. Product roadmap and business analytics, going to product development, prototype development, then for product launching. So these are the
9 steps of technology readiness level. If we file IPR and we sit in our office, there is no use of intellectual property rights. So intellectual property rights is basically for commercialization. So if you do not cover these 9 stages, then there is no use of getting patents like it is publication. We always mention go for publication and perish, publish or perish. But I am not telling that publish or perish, but go first filing patents. And these are the 9 stages of technology readiness level. In the first stage, we have only the basic principle. Based on the basic principle, we get some idea, research and feasibility. We reach TRL 2, TRL 3, analytical and experimental data. TRL 4, where component validation in your lab environment. So when you get idea in your lab environment, if it is workable idea, go for filing patent at that stage. You can file provisional specification at that stage. Otherwise, the question will come that if that colleague file patent, then what can be done? So during that stage, in the initial stage, you can file provisional specification. Then comes TRL 5, that component and validation in relevant environment. TRL 6, system, subsystem development. TRL 7, you need to prove your idea in the space environment. Then go for TRL 8, that is, it is almost ready and flight qualified. That means proof of concept is there. Afterwards, in the TRL 9, the product is in the launching pad. So these 9 steps is very important when you are thinking of any research, because our Department of Science and Technology and Biotechnology is providing research and development fund. And there the criteria is whether there is any patent and whether you have commercialized your product. So just getting patent is not the last word. You need to protect it, you need to commercialize it. So these are the steps of technology marketing. Idea to technology. How to move to idea to technology. You have lots of idea, but you do not know how to scan this idea. When you initiate your research, you do only the literature review, but you miss patent literature review. So patentability analysis is very important. So idea to technology, then scan the technology and get whether this technology is marketable or not. If the technology is not suitable for market, already the product is in the market, then don't go for filing patent in the same technology. Then you modify the technology. Here lies the actually role of Department of Science and Technology and Biotechnology, because we provide you insight that how to develop the technology, how to modify your technology. Already it is in the market, prior art is in the market, so how to modify it in such a way so that you get a new intellectual property, you new patent. So technology scanning and technology modification. So always we mention modify the existing technology. Almost all over the world, different technology has already been developed. So we need to modify it to make it simple, cost-effective, and user-friendly, or it may be speeder. The technology need to be modified. So when the technology is modified, then go for IP protection. So you need to know your location. If already it is filed, already it has been done by someone else, some institute, then don't go for it. Modify your technology, then go for filing. Then market plan and commercialization. So basically it is 3 to 5 year roadmap. But in the initial stage, if you are working in the workable idea, then go for filing provisional specification, then design thinking, then go for engineering, and lastly, validation of your engineered product. Whether proof of concept is there. If the proof of concept is there, you may work on this particular technology. So content of technology transfer. There was 6P. I have added this P, protection. When we were thinking of technology transfer, it was proper research, proper paperwork, pricing, publicity, partnership, and people's acceptance. But protection was missing. Without protection, if you enter into the market, then there will be mess and it will be taken up by someone else. So, and paperwork is also very important, because during the previous session it was discussed who will be the inventor. But when you are doing the work in your lab, but it is not recorded, who is particularly giving his intellectual component in this research. That regular digital or hard copy signature is required for component of work or component of participation in particular research, so that inventorship is not the major issues. Even I am working in this field for last 26 years. I have seen that IIT Kharagpur, STEP IIT Kharagpur, we are working with them also. Their startup also coming to our department. There is the major issues of inventorship, because many students, many researchers are working in the startup lab and they leave. Afterwards, their name was missing. So that is a very important issue when you are going for filing patents. So trends of IP in India, it is increasing trend. Even last year in 2025, more than 1.5 lakh patent was filed. When I was joined in department, it was only 2,000, 3,000. So it's a huge jump. And even granting is also fast, but here the surprising effect that Lovely Professional Institute, being the private institute, they are the highest filing in patent, even granting, their name is also highest. But our position, West Bengal position is 8th before 2020. Now it is 13th position, where India stepped into 38th in Global Innovation Index. Even in the granting situation, Lovely Professional Institute is the highest number of patent granted. So this is the era where we need to work on the emerging technology. So you need to find out which is the emerging technology. Now is the era of Industry 5.0. What is Industry 5.0? Industry 5.0 basically work on the computerization, on human component, on AI and all this. When we work with these two components, that means human component incorporate in robotic system and others, that humanization and machine. These two components combined with, it is Industry 5.1. So when we were in Industry 4.0, these are the area where most of the work already patented. And if you look into this, maglev train, this maglev train, it was patented in 1969, but when it is commercialized recent years in Japan and China, it was, and drone. Now in the world, drone is used everywhere, but this drone was devised 1962 patent. So this take long time to be popular in the market. However, now in the digital market, it is not so, you should not be delay in filing patent, because now everything is very fast. Technology is moving fast. Now you look into the 4D technology, 4D printing. It will revolutionize the world of technology. What is 4D printing? 4D printing actually enter one more dimension, that is time. Where is the application? Suppose there is a new 4D printing materials. That material will be applicable in the building, because time dimension is there. Humidity, temperature, pH will affect with that material with the time. And with the time, the material will change its configuration, and 4D printing material will sustain forever. So this technology is the latest technology, and there is a lots of patent, but the most of the patent is filing by China. You see, in the 4D printer technology, the Chinese component, Chinese-based technology is the highest patent granting authority, and China's patent in the 4D printer is 399. Where India's participation is not there. But in emerging technology, we are not working. If we do not make that costly technology in our cost-effective technology, that means we are scaling down, then it will be modified, then the technology will be like Make in India. So we need to work on those technology which is already they are in different countries, but we need to work to modify the technology to be available in the market. That was the question in the previous session. So when we make the technology available to the market, it becomes simple, it is cost effective, then it is the efficacy of the system. These are the patents, recent patents on 4D printing. So whenever you start your work on any intellectual, on any research, first go through patentability analysis, which is done through our department. Any help you can come to us, because without getting the knowledge of the patent existing in the market, you cannot modify your basic idea. The idea will be the repetitive idea. And most of the cases we have seen the idea is repetitive idea. And we suggest to modify the idea so that to make it patentable. Now, I'm giving a simple example of idea that jar opening system is not available in the market, but Coca-Cola opening system is there. But wherever, if we see that older people cannot open the jar easily, it is difficult to open the jar for older people. So if there is any jar opening system by any student, then it will be new in the market. So I think very simple way, so that it is marketable. Now I'm telling, every invention has some societal impact. So we need to look into that societal impact, because three important criteria for getting patent: one is novelty, second is inventive steps, third is industrially applicable. So this industrially applicable is very important, whether your idea is industrially applicable or not. Then you cannot go to idea to asset. Next, I'm telling that every invention has some financial impact. Here, Eli Whitney invented cotton gin, some machine to produce cotton gin very faster. So when the technology is simple, when it is faster, when the speed is high, then technology is modified. Then modified technology is patentable. So what is the difference between invention and innovation? We always say this is innovation, but invention is process or product, or new process or product, and innovation is ready to market product. That is the difference between invention and innovation. It is basically 3 to 5 year roadmap when the innovation to go to innovation, invention to innovation. Innovation means ready to market product. So intellectual property is basically creation of mind. It may be invention, it may be literary work, it may be artistic work, it may be symbols. Already mentioned, but I'm going very fast, how you can utilize this intellectual property for technology commercialization. So the concept of property has changed to product of mind. Even in every nanoseconds you are in a thinking of mind. So these all already covered, but I'm going very fast. What patent is? Patent is a grant for an invention. Mind it, not for a discovery. That means if you discover some plant, it is not patentable. If you discover some property of some material, it is not patentable. So mind it, it should be process or product or improved product, composition, formulation, then it will be patentable. Then it is given to, that was discussed, applicant, where in case of University of Calcutta, that University of Calcutta will be the applicant, and those working in the lab, the academician, faculty members, students, you will be the inventor. And there will be, as already mentioned, that there is IP policy in your university. So when it will be marketed, then there will be sharing of royalty. So every patent application in the lab of Calcutta University, that will be in the name of University of Calcutta. And as already mentioned, I'm not going to this, that patent right is for limited period, that is 20 years when it was filed within the geographical boundaries of the nation. It is very important. That means when you file patent in India, it will be effective in India. You can sell your right here, you can manufacture here, but you cannot it in US. But you can file patent cooperation treaty within 12 months of complete specification. So through this patent cooperation treaty, you can enter into the more than 150 country who is the signatory member of patent cooperation treaty. So in that country you can enter. So if by mistake you are not designated India, suppose you have filed in other countries, but through PCT, they can also, that company can also enter into India within the time period. So patent cooperation treaty is very important, and nowadays if you file patent, then the receipt will come that you can get the opportunity to file PCT. Recently patent office giving this alarming, that means that intimation to you that you can go for PCT. Then within the geographical boundaries of the nation, that means every patent is effective within the geographical boundaries of the nation. I am giving example of a patent, a lock. A lock may be patentable. Yes, if the composition, I was in NIT Jamshedpur, they devised some key which can open the lock and other key is used to just close the lock. So the design is functional design, that was discussed, that functional design is different. So the inventive feature lies there. And if there is a lubricant composition, if it is an organic lubricant composition for opening the lock, then it may be a new invention. In India, software is not patentable. However, software-hardware combination is patentable. How? Suppose there is a, till date, digital lock is not available in the market. Suppose I am here, I have forgot to close my door in the office. From here, can I operate? No, it's not possible. But if you have a new idea that I can operate my door from here through software-hardware combination, some digital lock, then it solves the problem. Then it is a new invention. So, like dishwasher, it is also software-hardware combination. Like washing machine. So that can be protected under Patent Act in India. So these are the three criteria: novelty, inventiveness, and usefulness. But most of the cases, the patent is rejected in inventive steps. What is inventive steps? Mr. Anjan Sen is also there, he will also explain. But I am telling in short, suppose there is 4 prior art which is almost related to your invention. But the concept of prior art, combining the concept of prior art, I get your invention, then it is not patentable. That means you just combine the idea of 4 prior art and get a new idea, that is not patentable. That means D1, suppose there is 4 documents related to your invention, that is D1, D2, D3, D4. But combining idea of D1, D2, D3, D4, if I get your invention D5, it is not patentable. So be careful before filing patent, that combination idea is not patentable, mere combination. But if you can intimate efficacy of the system, that combining this type of things, I get 100% efficacy. 100% is not possible, 80% more efficacy of the existing system, then it may be. So here is the first patent granted in the world, 1421. Even in the Greece, we know there was a competition where small soup was presented to king. And king says, it was an excellent soup. King says, that particular maker, that chef, what you want? He said, sir, I want that in your dynasty, no one is allowed to file the, get the patent right, get the right in your dynasty, that I am allowed to prepare the soup. It was said. So even 1421 in Florence, architect and engineer Filippo got this patent. There is the panka pulling machine already, it is the first Indian patent. Example of patent for this particular helmet, 43 patent for this particular different features has been protected by Korean inventor. So Thomas Alva edition you all know. So what would patent office look for? To file patent immediately. When I joined in 1999, I got the opportunity to find out this letter where Professor Bose is writing to Rabindranath Tagore, I am not interested to file the patent. But what happened? Marconi got the patent. But interesting fact is afterwards, Swami Vivekananda requested Sister Nivedita to file the patent in USPTO. Professor Bose filed this patent in USPTO, and it is the first Indian patent in USPTO in 1904. Detector for electrical disturbances. So Swamiji already encouraged to file the patent. So whenever we are looking into for any research, we need to think of filing patent immediately. Let's prior art, a simple error everywhere. but somehow it is modified, some hole has been introduced, and it is the needle. For this needle, we are getting the opportunity of so much of fashionable dresses. Simple heater, what is the problem of this simple heater? If it touches the bucket, there may be chances of electrification. But someone created some arrangement, some four floating ball is there, so it can float easily, so problem is solved. So it is the invention. Waste can to design a chair. The world first bionic idea invented by Australian inventor, and how much royalty it is there. So, through this bionic eye, some blind can see. So we need to solve the problem which exists in our environment. Then idea to profit, we can go to this, this process. And we can use licensing and franchising. Now the next question is, can idea be copyrighted? Here there was a question in a previous session that patent, in patent documents, how it may be copyright. Yes, patent, suppose patent, you have filed for patent, then it is your copyright. That means who has drafted the document is copyright goes to that. But as an inventor, as an author, copyright also lies if the patent, separately you have not filed copyright. Okay, so patent right also provide you the copyright for that invention if everything is there. But you can file again copyright for that invention also, because there may be more and more table, more experiment which is not disclosed in the patent document. So another question was there, that what is performance rights? That means today's my performance as a resource person. That is also performer right. So when some program is there and some authors are there delivering, if the program is now recorded and if it is like YouTube live going on, and the owner is Calcutta University, but as an author we have also the right, so that no one can violate that particular right. And copyright software. Software is copyrightable item. It is very easy to protect. You need to provide only source code and the original software you have developed. Then it will be protected in Indian Copyright Office. Industrial design already disclosed. It is outside design, shape, configuration. These are the design which is already protected in Indian Patent Office. There are different articles you can protect in Indian Patent Office. Now the trademark. The trademark is the logo or symbol which basically is product name. Like Coca-Cola, like Pepsi. So what is the relation of the product with the name of Coca-Cola? Is there any relation with the soft drinks of Coca-Cola? So the logo should be like this. There should not be any relation. Suppose you have devised some company of leather and name it real leather. That means you are describing your product. So when you describe your product, it is not basically actually it has description is given. It is not distinctive. It's like HP, half-eaten apple. What is the relation with the Microsoft and other Windows and all this? Is there any relation? So the trademark should be invented or created very judiciously, strategically, so that it may get registration. So another important Glucon-D and Glucose-D, before Dabur, when Dabur entered into the market, that they was actually used this father, mother and the boy, the same logo. And after the High Court case, they changed the boy playing in the football. Like Borolin, Boroline, Colgate, Collegiate, that is also into the market. That just changed the spelling, but same type of design. These are called passing off. Now, another important intellectual property already mentioned, geographical indications. But almost all geographical indications is facilitated by our department. That it was long back Basmati when it was taken up by our country, from our country by Rice Tech Company, 1997. During that age, there was no protection regime for protecting our intellectual property. Even turmeric was taken up by our scientist, Shumon K. Kohli. This is the US patent turmeric. Own healing property is the McDonald Advia. So during that time, there was no protection. After was GI Indication Act and rules was there. It is 1999 Act. So after that, we have protected a lot of number of GIs. Till that, it is 31, and within 30th of this March, we will get more 22 GI for this state, and it will be more 48 numbers. So this is the logo. So what is the efficacy of this GI system? Here I want to mention that Government of India, some program, GI Startup Challenge was there. Here is many students. You can take GI Startup Challenge. How? That means we have protected Dokra, we have protected Potochitro, we have protected Mango, all these products. But the problem is the product, in the product is the marketing. So you can get a new idea how to market, like supply chain mechanism, how to authenticate the authorized user. We have initiated already QR code based authentication. But here lies the problem. Like Bangla Rasgulla was registered, but the problem is how to go to this product to different countries, because only canning is the available technology, but it is very costly. So how to make this cost-effective marketing and self-life increase, that is another challenge. The next challenge in Dokra, the lead percentage is very high. To reduction of lead percentage, it will be more marketable. So these are the area and challenges. You have to find out the real life problem and work on these. Otherwise, it will be repetitive research and it will not be patentable. Most of the cases we have seen. Here you can see in one product, patent, design, trademark, copyright, trade secret, everything is there. I am telling in a very nutshell that, that this watch, I think many of you are interested having this smartwatch. But what is the problem with the smartwatch? That every time we have to give the charge. But if someone developed some sensor that it can take charge from solar light or any light, then it is the invention, it is the modification. That sensor-based new system may be patentable. Then come design, outside design, it may be hexagonal, any type. And trademark, titan or anything, copyright, engineering drawing. That means if you open up this watch, the engineering drawing, trade secret is manufacturing know-how. Coca-Cola company, we always suggest that whenever you disclose everything of your invention, don't disclose exact things. Always be the range of temperature, range of pressure, also based method you have to disclose. But the exact thing which provide you the market potential, that should not be disclosed. In Coca-Cola company, 2% knows the formulation and they do not fly in the same flight, because if there is any flight accident, like recent accident, it may chance to that the formulation may go. So it is like an example. So it is your property, how you can protect your trade secret, it is your strategy. GI, Swiss watch, that means GI means a product which for producing in a particular area, getting the spatial quality, like our mango, like Govindovok rice, Tulaipanji rice, a different price. Kalo Nunia rice, I think you don't know Radhuni Pagul rice. So these all are GI registered, but these are very good quality product. So you can get into the market and it's a very nice product. So it is the importance of GI to get our indigenous product in the market to protect it. So I think you have already got the both product, process, patent provided. Early examination is possible for Calcutta University if you are going for file, as you are the educational institute under Act and rules of government. So you can go for expedite examination. That is possible in India. So in a very nutshell, write down your invention, go for patentability analysis, whether invention is patentable or not. Then decide whether you are going for filing patent or not. Then draft patent with skilled person, filing of patent. If you are in the ideation stage, go for provisional filing. Then go for complete specification within 12 months. Then publication of the application request for examination. Fees you have to provide. The first examination report will come. If you can satisfy all the objections, then it will be granted, or otherwise there may be some hearing. So the patent system, you can see the ring pull cans, how much royalty? 1,48,000 UK pounds a day. So these are the efficacy of the patent system. In West Bengal Department of Science and Technology, Patent Information Center, there is a unique opportunity of idea clinic. So any idea, you can come to our department. We provide the facilitation for idea to intellectual property. How to make your idea to asset. So we have already some success story. We have Tekathon, Technology Grand Challenge. Here you can see that some students of Jadavpur University developed this nano composite based this cap, and if it is fit into the water bottle and you take the water through this cap, it will be automatically purified. So these are the development, and it is the waste, slaughterhouse waste to direct biofertilizer, a patent of the Jadavpur University. It is the outcome of our research and development project, and it is effective already. These are the leather, waste leather to product. Different, and this is another important, the smart water drinking bottle. If you pour the water from top, it will go through this middle portion and then go to the bottom. The middle portion is the another composite which can purify. So this patent was granted. Design was industrial design registration for the bottle and also trademark for Arpina. So they get 3 intellectual property for their invention. This is a very important success story I need to mention because many students here is there. She is a student of Jadavpur University Chemical Engineering. She started her business on 2022, and now she was in Shark Tank with her innovative idea like biodegradable plastics, and that was patented. She got design registration trademark. With all these, she was in Shark Tank and raised a fund of 10 crore from the market, and she now leading a company RBG with 25 new staffs, so that she is in the process of manufacturing. So this is the efficacy of the system of intellectual property. There is many more. I am not telling, only another important is Shumana Gadji Mistro. She is from KIT University. She is also Megali. She takes facilitation from our department and granted patent. She is 6 patent, 18 trademarks, 6 design. With all this, she is initiated fund from foreign department. And we have this facility already mentioned. You can click to our department idea. In this idea, come to this, download the form, fill up and send us to this. We will call you to sort out your any problem regarding idea to technology and patentability assessment. So emerging patent trends is this. And you all know, and I know that President Abraham Lincoln is the only president who has patent, and he said, patent system added fuel to the fire of genius. So we want to see many student genius from this university and other related university to get new patent everywhere. I end with this particular quote. Alice says, which direction should I go? Cat says it depends a great deal on where you want to go. But Alice says, but I don't know where to go. Cat says, in that case, it really doesn't matter which direction you take. But you have to take some direction. With all this few words, thank you. Thank you for kind patience. I think there is very few time for any questions, but if any questions, you can come to our department. And it has been Bigyan Chetana Bhavan, and you go to dstvt.bangla.gov.in. I am always there, and I think in the thank you slide was there, the number is also there. If you can see, last slide, you can see. So anyone interested, you can contact us anytime.
Thank you so much, ma'am, for that truly insightful and enriching session. We sincerely appreciate the depth of knowledge and vast experience you have shared with us. It has indeed been a privilege to listen to you. Now, first of all,
this is my WhatsApp number also. Many time may not be available. So if you are interested to get your idea to product, patent, technology development, we are facilitating in this regard. Anytime you can go to dstvt.bangla.gov.in. Thank you.
thank you once again, ma'am. We are really sorry because we are running 30 minutes late. We were supposed to have the lunch break at 2:30 p.m., but it's already 3:05. So we apologize from our side. Actually, the program is running 30 minutes delay. Now you all can have the lunch break. The lunch box will be distributed outside this auditorium at the registration desk spot. And I would also like to announce, please complete your lunch within 25 minutes because we will begin with session 2. So we will begin the session at sharp 3:30. Sharp 3:30 p.m. the session 2 will begin. Thank you. Enjoy your lunch, please. হ্যালো, হলের মধ্যে কিন্তু কোনো লাঞ্চ করা যাবে না। হলের স্ট্রিক্ট রুলস আছে, হলের মধ্যে কোনো লাঞ্চ বক্স খুলে খাওয়া এখানে যাবে না। আপনারা প্লিজ বাইরে প্লেসটা ইউজ করুন। আমরা অনেকবার বলেছি, আরও একবার রিকোয়েস্ট করছি, লাঞ্চ প্লিজ হলের বাইরে করুন। Those who are still outside, please call them. We are about to begin session 2. We don't have much time. We are already running late of time. Please, those who are still outside, please call them. Good afternoon, everyone. So now we are going to begin the session 2. I hope you all had a pleasant lunch break. May I request everyone to kindly be attentive as we are about to begin session 2 of today's workshop. We now continue our journey of exploring intellectual property, moving further into its practical and applied dimensions. Let us now proceed with the next session where we will gain further valuable insights from our esteemed speaker. I would like to request our guest speaker, Advocate Anjan Sen, to please come to the stage. Before handing over the mic to sir, I would like to introduce him to all of you. It is my privilege to introduce our next guest speaker for today's session, Advocate Anjan Sen. Sir is a patent attorney and advocate and the founder, principal and managing patent attorney of Anjan Sen and Associates, Kolkata, a firm specializing in intellectual property right across both Indian and international jurisdictions. With over 30 years of dedicated experience in the field of IPR, Sir has been actively involved in strategizing, drafting and securing intellectual property rights across patents, trademarks, industrial designs and copyrights. He has successfully guided thousands of inventors, researchers and organizations ranging from individual innovators to leading government institutions, research organizations and multinational corporations. Sir has also been associated with several prestigious institutions and organizations, including those under the Government of India, such as the Department of Science and Technology, Department of Atomic Energy, ICAR, and premier institutes like IITs and National Research Centers. In addition, Sir has been actively engaged in IPR awareness and training programs, contributing as a faculty member in workshops and seminars organized by national and international bodies, including the World Intellectual Property Organization. He has also contributed to academic publications and book chapters in the field of intellectual property rights. Mr. Anjan Sen, with such vast experience and remarkable contributions, we are truly honored to have you with us today. May I now request you to kindly deliver your lecture and share your valuable insight with us. The stage is yours, sir.
Thank you so much to all of you for your patience and post-lunch session as usual is the most difficult one. Definitely I will try my best to keep everyone alive. Now you see, I was listening to a lot of deliberations on IP through the preceding presentations, and as you people have also got exposed to the various branches of IP. Now what I will try to do is that in a more simplistic way, I would try to convey to you that what all these separate branches of law mean and how it may get into your practical, be practically relevant for your regular activities, and what are the pros and cons of IP which one need to be very cautious about. So I will try to traverse, because the timeline is very short, but I will try to pick up some examples, live examples, which I have myself been privileged to go through or handle, and we will see how things move on. So you see where from this intellectual property right is originating. That is the fundamental point. We need to recite in our mind that where from this IP is coming up. So IP is basically a creation of the human intellect. So it is only a human individual can create it. Like in the session of, I think Sri Shantanu sir, there was a query about that artificial intelligence and all these things. So till now, the law in India also on IP says that it is only the human intellect who can be the author or the proprietor or claimant of the IP. So as by the name also we understand intellectual property. So human beings have the intellect. So it is flowing from the human intellect. So that is the origin of intellectual property. Okay, so each one of you carrying a huge valuable resource of intellect, each one of you are a storehouse of creating intellectual property right. So that is the basic thing. So each one of you have the potential of creating IP. And I believe that in this world, it's not always necessary that you need to have a lot of money and a lot of other privileges to really excel in your domain. Now this is an area, intellectual property, where only by involving your intellect, you can rise up the ladder in your profession or as an entrepreneur or in any walk of life that you want to be really a guiding principle. So intellectual property right is very, very fundamentally important for all of us. And when I say that it is a creation of the human intellect, see, you would be involving your energy, resources, maybe the university's capital also in research and development. So it's a pricey factor. So you are putting in a lot of cost efforts into developing an IP or an intellectual property. So accordingly, it is important that after spending so much of intellectual effort and then putting in a lot of money, resources, etc., and then tomorrow when you try to utilize your intellectual property rights, someone else comes and straight away copies it or lifts it straight away. Now that is very damaging. So this is the requirement that for which the protection of the creation of the human intellect needs to be guarded or protected by the laws. And that is where people like us who are basically from the legal domain also need to get into this, IP right protection and coverage and all these things. So it's a handshaking between the intellectual property creator and the legal domain through which you get the property rights. Like for example, I will give you a very simple example because I just want to clear up your minds, because young minds over here, they need to just clear up their minds and then you can apply IP in your regular activities. Like for example, you own a building or a flat. You go and register that before the municipal authorities. Don't you? Each one of us who are owning a building or a flat, you will find that your records are there before the municipal authorities. And those municipal authorities, when they record it, you will find they will enclose in the deed or agreement through which you get to that ownership right, they will put across a margin of the land or the flat which you actually own. So there is a clear demarcation of the ownership right attached to the real estate. Okay? So that is the fundamentals of real estate or the property right, physical property right that we have. Even for your car, the motor vehicles is there, the authority is there, you go and register that so and so car, whether it's a Mercedes or whether it is any other Maruti car or anything, you go, the number traces back to the owner. So the motor vehicles are recording it. Similarly, when I say that intellectual property is created by the human intellect, so who registers it? There should be some authority. So this is where the authority of the Intellectual Property Office comes in, and they record this ownership rights of various forms of intellectual property right. So this is how the law is coming into the creativity of the human intellect, and you are getting it recorded and registered by the authorities. And why these authorities are recording it? As I said, that the creation involves lot of effort and money, etc., and time, of course, in today's world. And accordingly, if you want to exploit or really claim ownership on that, you need to retain control over the right. So these authorities who record your IP at the offices, they give you reciprocal rights as per the various statutes and forms of IP, and then you enjoy that right. This is the basic fundamentals of the IP. So you see, this is very well codified in one of the United States Supreme Court cases, which says that the economic philosophy behind the clause empowering Congress to grant patents and copyright is the conviction that encouragement of individual effort by personal gains is the best way to advance public welfare. So they say that you need to encourage people to come up with their intellectual creativities for public welfare. So intellectual property right is not always a professional, rather I would say it's never only a personal right. By way of your creation and you pass on to the society, society gains by it. Suppose you develop a new drug and the patients benefit. Can you imagine the amount of satisfaction that you would get out of it? Can any amount of money give you that satisfaction? Look at the thrust that an intellectual property right can give to an individual. Look at it. And you are all young minds. If you think in these terms and you start developing, you can imagine the wealth that our country can generate through intellectual property. And this is very vital. Today the war, we are all hearing about war today, and at the borders so much of security issues and this and that. But you see, internally also, we are struggling with a war on intellectual properties. So each country's human resource need to develop creativity and IP rights so that they can enjoy proper sovereignty of the country and the nation. And not only protect the rights in the home country, but also expand it outside our country and earn foreign exchange. So this is another sort of, it's not like simple boundary protection. It's another way of developing our country, and it's vital. In today's world, you cannot develop a bit without intellectual creation or intellectual property rights. So this is the bottom line. No easy way out. We are in a highly competitive world. We need to all get up, wake up, and look forward to creating IP. So this is the importance of IP. So as I was mentioning, that these rights are not granted automatically. So accordingly the law comes in, and lawyers like us, we also step in to allow the proper protection like your real estate or car, etc., etc. So there is a definite form in which you can get these rights. So that is why these are governed by various statutes like the patents. I think you must have heard since morning, patents. So patent is governed by the Patents Act 1970. And you see, I have highlighted with this red cap blocks after Patents Act. Those are the guiding legal requirements to qualify for grant. So it should be absolutely novel. So what do you mean by absolute novelty? It should not have been published or made available anywhere in the world on the date of claiming of your patent rights. So on the date you claim your patent rights at the patent office, that particular advancement should be absolutely novel. It should not have been transferred, it should not have been published by someone else anywhere in the world, not only in India. That would have been within the boundaries of India novelty check. But the law says that it's an absolute novelty check. So very, very important rider. So whenever you are into patents and you want to file a patent, you need to ensure that you are doing a proper search, that your subject of claim is not published anywhere in the world. So fundamental criteria, patent search or any publication search, very important. Next step is inventive merit. So not only in patents, see it is very important, not only novelty doesn't satisfy, like for example this microphone is black. Tomorrow I say that I put a fluorescent color to it, and like we have our in dark also, like there are some paints etc. formulations which glow. So I bring in that color from the market, I paint it and say that this is for the first time, this is a microphone which when I will give a lecture or a presentation at night in the dark in this auditorium, it will glow and either put a glowing effect on the surroundings including the speaker while the others will be in dark. So I claim that this is my invention. Novelty done. Nowhere in the world anyone has done this particular novel thing. Purchasing from the market the fluorescent color and applying it in the microphone to get to that technical effect. But the patent law will say that that is obvious, there is no inventive step. Because this color is available in the market, you have just gone to the market, you have seen the properties of the color, and instead of painting that in a car or any window or anywhere else, you have just painted in a microphone. So it's just a 1 + 1, 2. So 1 + 1, 2 is not inventive, it is obvious under the patent law. So whenever you write a patent document, whenever you do a research and you want to project your claims in the patent office, ensure that your write-up has a characteristics or some exemplary illustrations which will justify the non-obviousness factor of your advancement. This is very important. Non-obvious, it's a very, very techno-legal jurisdiction. But nothing to fear about, but only thing, your patent document must have spices of inventive merit in the technical domain. It should not be something which is a ready assembling of the known art. That is not allowed. So that is the next step. And the third one is the industrial utility. So every invention, see, you people are from the scientific domain, your research findings can be published in well-known journals and publications. And you can get accolades out of those publications and also from your peers and colleagues. And you can also be called to well-known authorities across the world to read a paper or present your finding there, this and that. But what happens to that? That is, you are just publishing your knowledge to the world. But it is not getting any industrial applicability. Tomorrow that knowledge can be applied by someone from the other country and a patent can be obtained in our country and our public at large will pay royalties for that. So just look at the scenario or the practical implications of IP. So you develop an intellectually creative advancement, you publish it. That term publish and perish I was hearing in the morning and one of the presenters were using. So that is what happens. You go and publish it without any patent and without thinking of any industrial utility serving the society, and you actually lay down your own intellectual creativity in the hands of others and come back from that country very happy reading a paper there. Those days are gone. Very competitive. All of us know, I don't have to tell anyone that how much competitive the world has become today. We all know about it. No one is living an inch. So very important, don't miss the bus by filing a bogus patent application. File a valuable application which will have novelty, inventive merit and industrial utility. Very important, practical insight. practical insight. Then I go into the next one, that is industrial designs. We have been hearing for it. Industrial design is nothing unlike patents. Patent covers, technical advancement. So any machinery having some gearing mechanism or some functional novelty or advancement which is inside the machine, that can be covered by a patent. But you cannot cover those sort of functional attributes in a design. Design law says that you protect under the designs law anything which is visible to the eyes of the customer. So designs law is basically framed for designing of products. So we go to the market to purchase a mobile phone. Apart from the functionalities of the phone, we sometimes look at the feel of the mobile, how it holds in terms of its shape, or what are the key buttons and how those have been arranged. So these are all design aspects. So companies usually register the design, shape and configuration of the product or any ornamental pattern on that, like jewelry designs. You can go and register it as an industrial design so that other jewelers cannot readily adopt it. Fashion designing is a very hot topic in today's world. So if you develop, I am not talking about just a very glamorous outfit, but suppose you are able to develop an outfit which is very comfortable to the wearer in summer or whatever, in winter, whatever. And that has got unique functional attributes. You can go for patent for the functional part, and for the external look of the outfit, you go and register it as an industrial design. So look at just visualize the branches, differences of IP vis-a-vis the various products. In designs also we have got that absolute novelty. So no product design which is published outside India can be covered for a fresh filing or coverage in India. Next one is trademarks. Trademarks is all these Nike, Apple, this logo and this and that, through which we know the origin of the goods, from where it is coming, or the authenticity of the goods. These are all covered by the trademarks. Even service marks are also covered, like for example DHL. They do not sell any product, okay? They give services. Like for example, we are a law firm. We have a logo. That logo is registered also in the legal services sector. So any services which you believe that it is giving some unique services, people should be associated with that logo, you can go and register that. So this is all coming under the trademarks. And finally we come to the copyright, that is governed by the Copyrights Act, which is original creations. Like you write a novel, you write a publication, you do an artwork, you go and do a painting of Taj Mahal, and that is very unique. You can go and get it copyrighted. So you see, between copyright, one very fundamental and very important thing I just want to convey, that between artistic copyright, I am talking about the paintings of Taj Mahal, I am talking about some sort of an artwork that you do, or the Apple logo, etc., etc. So these sort of artistic creations are actually categorized for copyright registration under that 1957 Act. So you can go and register it as a copyright. But I was also telling you that industrial designs are also there, where you can register the outlook of a finished product, finished industrially produced product. Remember, designs are industrially applied products, okay? Whereas if I do a painting on a plain piece of paper, it is not an industrially produced product. So that is an artwork that goes under the copyright law, okay? Whereas if you are applying the artwork in a industrial, suppose M.F. Hussein's painting, I just apply it on a t-shirt through industrial process. What happens? I am applying an artistic creation into an industrially driven product. So then what I am doing, I am shifting my base of intellectual creativity, if you say, from the artwork to the industrially produced product.
So in that situation, the law says that you cannot have the same artwork covered under the copyright as well as the design. So it says that, like you know, this copyright, it is always attached to the originality of the author. So this M.F. Hussein's paintings or any publication, write-up, novel, poem, you write original thing, or computer software, these are all original copyrightable subjects. So what sort of rights do they give? They give you original, only reproduction rights are only with the creator of the that artwork or the literary content. But when you go and apply it into an industrial product, like the example I gave you on the putting the painting on a t-shirt and reproducing it, then the law says that if you reproduce that more than 50 times, then your copyright, which is a very extended right, this copyright under the Copyrights Act actually gives you right for 60 years after the death of the author. So imagine the extended period of right because of the respect to the originality of the creation. 60 years after the death of the author. So author's lifetime plus 60. Whereas if you apply it in an industrial product, it comes under the Industrial Designs Law. Then Industrial Designs Law gives you a maximum coverage of applying that copyright exclusively by you for 15 years. Initially 10 years plus 5 years of renewal. So if you apply your artwork to an industrial product, you translate your right from the copyright claimable subject into an industrially applied product, and then your that 60 years right goes off and you remain protected for 15 years for that thing. And after that, people can use your copyrighted artwork for any other industrial application. So you lose the right on the copyright. These are bit complex it may be, but I am trying to make it more lucid by examples. So this is what are the various branches. Now you see, this is what has happened is that all these branches are basically broadly covered under two things, as I was using the term industrial. Why I was using it, look at it on the left hand side, all these rights, these are all some way or the other attached to industry. And on the right side is the copyright thing which I gave the example. Only artwork, only original creation, 60 years after the death of the author, blah, blah, blah. So that is that side. So there is a two spectrum of coverage of IP. This is how the IP laws are divided. Very important. So make your minds clear and concise. Make it lucid. Let us not complicate things. Let us make it, because we have to go a long way. We are already very backward in terms of taking IP at the very highest level, which the talents like you people over here, the technical pool of talent that we have in our country, our intellectual pool of talent that we have in our country, is a rare species in the global domain. But unfortunately, we have not coordinated or guided our intellect towards this. Now it is a high time. If we want to save our country, save our nation, you have to be focused. Please focus your energy not only on earning academic degrees, but also applying your knowledge for this sort of intellectual property development and serving the society and the nation. This is important. So academics is now no more only personal. Remove that from mind. If you earn a degree, it will always with you. People will always respect you for that. But please extend that to the common good. That is where our country, the society, the poor farmers who are toiling to give us food regularly, they can really survive. Let us think in these terms. Let us go a bit farther through intellectual property rights. So this is important. So as I was telling, there was a lot of issues on idea, patenting, and today's I think the topic of the day is also an idea. I want to make one thing very clear, that idea as such is not an intellectual property. Unless you, in any forms, You cannot go to the patent office and say that I have got an idea to develop a ladder which will take us to heaven. You cannot just put a claim that you are the first person in the world who has claimed before the patent office that I can develop something that. Patent office will ask you what is the actual form in which it is you have developed it. And then you will be zero if you don't have any technological support to do that. So ideas are never patentable, never an IP right. Ideas have to be reduced in the form of an expression. And the expressions are in very ways, like paintings for copyright, writing novels, writing songs, lyrics. These are original creations, so you are reducing idea into expression. Song lyrics, you are writing it. Then if you write things in a tangible media, then only the authorities will be able to examine and allow you protection. Then the law judiciary will give you the copyright. If your rights are floating, non-definitive, just idea-based, nothing, bogus. We receive phone calls every day, एक idea आया है दिमाग में, patent करवाना है. Now because of this IP nurturing, all people are running for patenting of ideas. Now they don't know what is what. Only thing that you can do is that if you have got an idea, I won't say that you throw the idea in a dustbin, but if you have got an idea, then you go and file for the idea provisional patent application. But within 2 months, you have to come with expressions to complete that provisional to get a valid patent grant. So idea as such will not take you in the next stage of prosecution. So that is not possible. So these expressions are actually the building blocks of IP. So from idea, you reduce expression, and these expressions give you building blocks, and based on which, examination of which, you get the various rights. So these are the various forms in which, these various categories of IP are there. Copyrights are the literary work, musical work, choreographic work, artistic work, architectural work, figurative, cinematographic work, photographic works, programs, computer programs. Of late, this is a very hot topic because every device requires a program these days. So people are creating original softwares also. So database is also a very important, very intelligent databases are also copyrightable. So then India is also, you see, unlike other branches of rights like patent, design, trademark, the law on copyright says that it is not necessary to go and register your work before the Copyright Office. As soon as the work is finished, the author gets the copyright on the work. But the point is that suppose someone copies your right, then it becomes very difficult for you to really appreciate or take legal action against that party. So it becomes very complicated. So it is better to register your subject before the Copyright Office so that if there is an issue, legal issue, because these are all IP rights means legal. So if there are any issues, you can get some headway to be out of it. So these are some of the protections that owners of copyright get to reproduce the work, to distribute copies. All these original software, Microsoft Office, this and that, these are supposed to be bought in the original format because they are the authors of that, they own the copyright. So the spurious copies that we sometimes get loaded in our laptops, those if in case the Microsoft Office fellows, they want to take action under the copyright law, they can do that. But they do not come at that level and hurt us, but that can be done because the copyright protects them. So now we will now I was talking to you about the industrial design. Look, this is an artwork of this is a famous biscuit from Britannia. Now this is an artwork attached to that. Now look at it, this artwork has now got translated into a biscuit, industrial production. So now it becomes an industrial design. And Britannia has registered that and exclusive rights. They have marketed. Even today you get it in the thing, but I think 15 years have gone by. More than that. But it's an industrial. So this is how simple things. Look at a paint container. Surface ornamentation becomes an design. copyright. Industrial design. So I believe you are clear now on the artistic copyright versus the industrial design copyright. So these are all industrially applied products, okay? So this comes under the Designs Act. So look at it, someone painted the container box in a unique way like this, and they were selling it. It was quite popular. Some fellow came up with this. So the law said that this is very deceptively similar. So accordingly, the owner of the creator, the first proponent of that, he gets the right to put it on containers in that color combination. This is another example, you know, very old days, I think the young people over here may not have seen, but we have seen, there was one Japanese, you know, that Casio calculator in our times when we were in our schools at that time. And it was very famous, handy, and people used to use that calculator to do a bit of mathematics on a regular basis. Now some chocolate company in Japan, they use that particular design of the calculator to develop industrially chocolates. So the children liked it very much because their parents were using the calculator, and now the children gets a Cadbury with an applied design of the calculator. So look at it, some creative external look on one product getting applied into another diverse product. So these Casio fellows, they took that chocolate manufacturer to court in some time at that point of time. They said it's our creation. Now whenever we register any design, or for that matter trademark, we have to specify that for which class of goods this design is getting applied, okay? So electronic products will come under one class, and food items like Cadbury's will come under separate class. So the court held that there is no inspiration that a electronic calculator can be applied to a Cadbury straight away. And so the court held that this one was an original application. So applying that to Cadbury was an original application, and their registration should be retained. So this is an idea where you can use existing designs in a totally different product to give it a totally different outlook. So that is also feasible. Like for example, this one. Look at the religious insignia that we are all well known about this. Look at this. So here someone comes up with LED lamps which are having this well known religious LED portions. So to the eye of the end user or the customer, I said that design, industrial design is for the customer's end, okay? So the customers, if you get this design, you love it. You may love any of these. So this is the magic of designs, industrial design. So you can do that. So this is although existing in some form, but applied in a different thing. Got it? So you can, this is what under the designs law, if you read it, they will say that designs are registrable for novel designs or original designs. So these are original in application. That's why they say it. So not novel, it was existing, but original in application. So accordingly, you get this thing. Now this one I will give you another example. Just do let me know if I am overshooting my time. So this is an example of a bottle carrier. Look at it, this is the bottle carrier. Very, very good subject matter, and someone got this design registered. So you can have this, here they are showing that you can carry 3 bottles, but you can also extend it for 5 bottles. You can also have it little reduced for 2 bottles. You just put the perforations according to your requirement. So my suggestion would be that this sort of inventions, as I was telling you, that functional part gets covered under patents, but what is visible to the eye comes under the designs law. I was telling you a while ago. Now here To the design part, it is three bottle carrier, but I am contemplating that I can carry 5, I can carry 2, I can even carry 6. So if that be the case, I would have preferred to go on and take a patent coverage for this. So the patent law has a, if you people have read any patent document, you'll find at the end of the patent there is a claim where we say we claim and you claim these things. And there's a peculiarity to all these claims. These claims are always in a one single sentence. So there is no full stop in each of the claims. So it's a one single sentence, and that is done so that you define your thing in a very constructive manner. As I was mentioning that when you go to register your real estate or car, you give numbers and this and that, so that it is very specific. So technological advancements also, you have to be specific. You have to be very bounded what you want to claim. Otherwise, this patent office controllers, like Mr. Dev was here in the morning, he is the controller. So he will ask us questions if we make it vague. That what is this? I cannot understand what is your claim. So we have to satisfy him that, okay, no, my claim is this thing. These are the integers I want to claim. This is the novelty part, and then he will allow it. So you have to think tangibly what is the definitive part of your claim. So here this fellow missed the bus. They didn't do it. It's a long one. I'm just taking it as an example to guide you on to something. So this was registered as a design, but after registration, it was a very popular, carrying commodity for visiting the market and having multiple packs you can carry in one hand. So it was a very user-friendly thing, this bottle carrier. But all of a sudden they found that they got a notice from one of the people citing that you have infringed our IPR. And they were really stunned because this was a very novel design. No one had done this sort of a bottle carrier. And now how come this fellow serves us a notice? So they were really stunned. So what happened? The reading into the notice, they found that the error that they did was the notice was getting served by this company, Danone. Now what they did was, when they put the representations at the patent office, they purchased random bottles of these Danones, some soft drinks or something, and they put it as an example before the patent controller. That was not necessary. But they said that your use of our bottles in your design IPR amounted to infringement of our trademark. So you are liable to pay us damages. Look at the level of consciousness that we should have. Level of consciousness, very good in advancement. Very user-friendly carrier. What has happened? You yourself have landed yourself in trouble because of lack of proper IP knowledge. So you went to the market, purchased some random bottles, put it there, taken snaps, deposited. The patent office doesn't recognize that. They allowed you, but now it was a time for cancellation. So their design got, good design, lost because of lack of IP awareness. All of us must be IP. You cannot say that I will be in today's world, I will be a very good academician, but I will ignore IPR. Those days are gone. Now it is a new challenge. Only textbook knowledge will not help. You have to fight out your knowledge domain or intellect in a different platform. And that platform is this IP generating platform. This is vital. This is vital, important for all of us. So this was a case. Now I will slowly, after this copyright and artistic creations and designs, I will slowly shift, if time permits, to the patent part. Again, I will try to put across with you. Now what this patent does, we have been thinking about, you do patents and you do earn money and all these things, so assets creation through IP. Now this is what actually patent law says, that if you get a patent right, as we were discussing also in the morning session, patent rights are geographic boundary driven. So if you get a patent right in India, it is not enforceable in USA. You have to go and take a patent right in USA. Similarly, US citizen needs to take a patent right in India if that needs to be exploited. So you get a patent right, and then you can prevent others from using your patented technology. Otherwise, they have to, if they want to use it, they have to take a license and pay royalty to you, and you start earning as an asset. So you can give on rent your bungalow and earn monthly rents. Similarly, you can give your invention to someone to practice and earn royalty out of the produce that they do out of it. Look at the generation of asset that IP can do. It's immense. And it is not that this IP and all is connected to rocket technologies, that no one is bothered. Those are very high-end, different domain applications. In our day-to-day life, when we go to the market, we are flooded with IP. Right from early morning to the late in the evening, even brushing our teeth in early morning till late night. The toothbrush may be having an IP. The angular toothbrush, the way the bristles are put up. These are, several patents are there. So you can have IP on that. So this is how IP can. Now I make a simple comparison between your conventional scientific publications versus patents. So you see, may not be inventive. As I said that you have to have spices of inventive merit in your patent document. When you write a scientific publication, you mostly write on the findings of your exemplary studies. You just relate to that. But you do not usually relate to any industrial use. So putting across a publication in the market or public domain without thinking of its whether it is fit for any industrial utility is a suicidal approach. Stay away from this. Don't do that. There's a difference. Publication and earning, your academic mileage or flooding your resume with publications, that is one thing. But that is different. If your mindset is on that, please don't come for patents. If your mindset changes, you want to use IPR, then think differently. Don't think in the same platform. So there are clients, academically very stalwarts, who will send their publications to us and say that I want to patent this and that. We read the patent document, we find that the industrial utility part is not there. So we ask them questions naturally to put it in the right framework. Now, if he is a very, very renowned person or this and that, and then he can, there are situations when they say that my publication is accepted by so-and-so in the international domain, and how come you are asking this industrial utility aspect again? Although we try to modulate our questions and try to get back the answer from such reputed persons in technical domain, in the global domain, I would say. But then why do we do that? Because if we go by the flow of the publication in the patent specification, that will be refused by the patent office. So you will face a refusal. Better don't face that refusal. So these are the cardinal stages or qualifying factors in your patent specification. Remember, without having these insights in your patent document, please do not file any patent application. Absolute novelty, do a search. Inventive merit, non-obvious factor. Why it is non-obvious? What you have done is not a mere assembling, mere 1 + 1, 2 from the knowledge domain, well known. You have to explain it in your patent document. Put few paragraphs on that. Very important. And I can tell you that if you develop this art of justifying inventive merit of your technical advance, you will fly in a different domain. I think your own intellectual creativity and own sphere of thinking will totally change, diametrically change. There are inventors, well-known inventors from Department of Atomic Energy, who flew down from Bombay to our office for filing a very urgent patent application. Then while discussing the application, they said that, I asked them what is the closest thing that you have. And he said that only one Japanese fellow has done this thing. Then he pulled out a Japanese publication and he showed me that thing. I said, Baba, then this publication and this one, you have done something new, but then your write-up doesn't carry any examples to show that that one, that technology will not work in your module which you are thinking of covering as a new item. So people can extend that thought process into this and you will end up in an obviousness phenomena. Then I said, you either run examples to show that that modus operandi doesn't work for your module, or you have added something which is missing there and that's why their device will fail, which your device will be successful. So he got the point, he went back to his lab, he came back with proper data, and then he not only filed and took patents in India, he took patents through PCT International Application and got several patents outside India. And he is also commercializing that. So asking the relevant questions on yourself, developing this inventive merit funda, and then putting across in the patent document is very important. Another very important thing, this patent specification is a techno-legal document. I am repeating again why lawyers like me feature in this IP domain. Because patent specifications are not only a technical, just a raw technological document. It's a legal document. It gives you protection, prevents others from practicing your invention. Very important. So a patent document needs to satisfy technical workability. There is a section 10 of the Indian Patents Act which says that if your invention is not workable, then you cannot patent that. It must have a workability, industrial workability. So that is one part that needs to be discussed with examples, illustrations, and the other part will be the legal aspect, that you have defined the technology in the right perspective. I will give you one more example. I have a few, but should I? Yeah, one more example. This is of a startup. How competitive the world is becoming. This is an example, live example, which I had come across in my professional services. This is a startup from Calcutta, Safe Automation Services. Now what they did, they developed a robotic watercraft for navigation on water carrying one or more person. The robotic watercraft comprises hydrodynamically designed open hexagonal body floatable on water, at least one ducted propeller on each open end of the hexagonal body. Each set propeller is adapted to selectively provide forward and reverse thrust to the hexagonal tender. Now this is how it looked, you see. So it goes through remote, someone who is drowning can just get hold and he will just bring it back. So this is how it works. Now what happened, all of a sudden again like that earlier notice on that design case, now they received a notice while their application was pending and their tender application was pending from a party which we are supposed to learn that they have also participated in that Navy tender. And they said that we have got a patent in India which is prior to your patent application, and accordingly you withdraw your patent application and also withdraw your tender applications and this and that. Don't commercialize your invention. So this was a prior dated claim by some Portuguese company who filed a PCT international application and then routed it into India for coverage. So now look at the scheme of this development. It's also a remote thing. It looks almost the same. And more importantly, as I was telling, that this is the claim part that they had. And I said that, the claim in a patent document is vital. That is the legal scope of your document. So when that notice was given to us for analysis, we traced down there this patent, and then we also traced this claim that they had. Now we found that their device in claim 1, although the device functions for the same purpose, it looks also to have an U-shaped thing. As a carrier, people can hang on to it and come back to the shore. But its claim 1 read that it can be operated in both ways. So even if it gets upside down, it will be still operational, their one. But our one was of a device or a configuration which will only work on a single-sided module. See, our fans are there only in the bottom part, so if it reverses, it won't do that because we have gotten aerodynamic design to that. They don't have that aerodynamic design. So ours one doesn't have that problem of toppling. It will keep with the speed required to save the life of the person. So we had got something different, and we have avoided something which they have essentially put in their claim 1 of a two-side operation. So look at it, the same subject, but the legal claiming, they could have made it one-sided. Anyone who developed at that point of time, if he would have extended his thought process a bit, he would have covered it for one-sided coverage also, instead of both the sides. Both the sides could be a preferred embodiment. But they limited their claim to one side, and then we wrote back a huge reply to the legal notice, citing that you are giving us a false threat and we will take action against wrongful threats made against our clients. And we cited that how word by word their claim is not matching with our legal claims. So this is how we distanced ourselves, and then they finally got the patent grant, and also they got this Navy order also, and they finally interacted with our Honorable Prime Minister also, because Prime Minister was also very happy that an Indian startup was able to supply Navy with this watercraft. So this is how you see again IP, and they did a design registration, as I said, that design registration for the outlook, and for the functionalities they went for the patent coverage. So this is how that part was covered. This is another very live example where you see we have laws which are differently administered in various jurisdictions. Like in India, method of treatment, I will just wind up, just one more. Method of treatment things are not allowed in India, but it is allowed in USA. So accordingly, this was a very important advancement done by Department of Atomic Energy, method of adjuvant treatment with chlorophyllene containing therapeutic preparation including for radio protection of normal tissues during radiation therapy. So when a cancer patient is subjected to radiation therapy, even the live cells, they die. So they say that if you administer chlorophyllene, that is a plant-based extract, very commonly available, if the patient takes it before the radiotherapy, then the live cells' death is decreased synergistically. So this was a very good, fundamentally very good advancement. So they couldn't patent it in India because method of treatments are not patentable, but they got the patent in USA, and then it was done. So I will just close it up. I think the time is running off. This is just an example of where we are standing today. You see, at 2026 we are on IP awareness. 1849, a person who is not even an academic person but a farmer, he developed this safety pin. Still today every home possibly has it. Look at the importance of the societal impact that an IP can give. And in that time only, this fellow not only conceived the actual safety pin that we have it in our houses, every house, but also what has happened was that the Patent Cooperation Treaty, that one common international application for multiple countries. But that international application only gives you the priority in various designated countries, 150 plus countries, and also generates a global search report, like where your technology stands as far as absolute novelty is concerned. So you can use that single window to check the novelty part, but if you want to take rights again in the designated countries apart from your home country, you have to go and register that search report and that application in the respective countries. So that is also, even if you take the PCT route single window filing, but for taking the actual IP right, you have to go and register in the respective domains. That is because the unified patent system law has not developed, although it is definitely a requirement.
Thank you, sir.
Thank you. Thank you. Just a moment, let the microphone.
Suppose I have filed a case against copyright infringement and the case is solved. Then I am not happy with the judgment. After 1 or 2 years or few years or few months, can I apply to reopen the case?
That is a, means where did you must have filed the case in a court of law?
It was solved.
It
But
was solved.
I'm not happy.
So,
with this
so
judgment.
that is in that case, it goes under the Civil Procedure Code. So whenever, whether it is IP right or any criminal right or any other form of violation, if someone approaches the court for relief and the court passes an order and the court system runs from district court, then high courts, then Supreme Court. That is the hierarchy of courts. So the IP law says that the lowest court in which you need to file a complaint is before the district court. So suppose you have filed a complaint at the district court and the order is passed and you are not happy. In that case, you have to go for the appeal to the next higher court, that is the high court, within 3 months. So that is governed by the civil procedure courts. So you have that remedy by approaching the next higher court, then the division bench, then possibly the Supreme Court.
Next question is that we have often heard that cases are solved cases are solved after out of court settlement. Then if a person he is not from plaintiff part of plaintiff or defendant, actually common people or any other person, third party. So if you want to know about the terms and condition of the settlement, can he get that information?
This is a very complex issue.
Actually, I want to need, actually I am doing research on copyright, so I have to know about that fact.
Fact is that, see, there are cases in the courts of law also where due to certain, suppose I'll give an example, there's a trade secret, someone violated someone's trade secret and this plaintiff has gone to the court. Now, this fellow is fighting on an ownership on a trade secret, not a public domain knowledge. So the court is also bound to consider it because that is also a form of an IP. So the court will consider the trade secret violation, but the court will not possibly give any indications that that fellow opens up the trade secret to the public at large because he has approached the court to get an order for it. Because the subject matter demands that to be still kept secret for its property rights. In your case also, if there are cases where copyrightable subjects may be a published subject, there may be an unpublished subject.
In the case of published subject.
If it is a published subject, then the terms of agreements, I think you can get it. There is another route like RTI we have that you can explore the RTI avenue and if it comes. But if there are certain conditions to this subject which prohibits even the courts or the judiciary from laying it open, the terms and conditions, then possibly maybe that they were two business partners at some point of time, then something has cropped up. So they may settle their doubts amongst themselves. So maybe those are some pros and cons to be considered by the judiciary, whether they will leave it open or not, the terms and conditions. Okay, thank you so much.
Thank you so much, sir, for that insightful and highly engaging session. We truly appreciate your valuable guidance. Now, we are moving to the next lecture. I would like to call upon stage the coordinator and the founder of IPR Cell, University of Calcutta, Professor Shobuj Kumar Chaudhary. Before giving him the mic, I would like to introduce him to all of you. It is now my privilege to once again invite a distinguished academician and guiding force behind the intellectual property movement in our institution, Professor Shobuj Kumar Choudhury. He is a distinguished professor and former head of the Department of Library and Information Science, University of Calcutta, and is presently serving as the coordinator of the IPR cell as well as the prestigious position of the librarian of University of Calcutta. A scholar of exceptional merit, Sir is a gold medalist from the University of Calcutta and holds a PhD focusing on the impact of intellectual property rights on biodiversity and biotechnology in India. Sir has also received prestigious international recognitions including participation in the WIPO WTO Colloquium in Geneva and fellowships such as the Shastri Indo-Canadian Fellowship at York University, Toronto, and the Research Excellence Fellowship at Central European University, Budapest, as well as CEU HESP Fellow, Central European University, Hungary. In addition, Sir has further strengthened his expertise through several prestigious international academic programs and specialized trainings in the field of intellectual property and related domains. Sir has successfully completed advanced courses from globally renowned institutions such as the Technical University of Denmark, Copenhagen Business School, Duke University, Emory University, and the University of North Carolina, securing distinctions in key areas like patenting in biotechnology and copyright for multimedia. Professor Shobuj Kumar Choudhury has undergone specialized training at the Rajiv Gandhi National Institute of Intellectual Property Management, Government of India, completed the prestigious Copyright X program from the Harvard University. Furthermore, he has undertaken certified programs from institutions such as the University of Rhode Island and the University of Pittsburgh, along with completing the general course on intellectual property from the WIPO Academy, Geneva. His academic and research contributions, particularly in the domain of IPR and information system, continue to inspire and guide students, researchers, and innovators alike. Sir, we are truly privileged to have you with us. May I now request you to kindly address the gathering and share your valuable insights. The stage is yours, sir. Thank you.
Thank you. Sorry. Yeah. Thank you, Jishan, for your generous introductions. Please bear with me, I'm a little bit under the weather. So my voice is not actually gone with me. So bear with me. So I will not take much time. I will simply, from the morning to this time, you have learned so many things about this patent, design, trademark, geographical indication, semiconductor, plant breeders' rights, and the databases. I will not be focusing on that. Particularly, I will be focusing on what we are doing in the University of Calcutta. That's important because this is 170 years old, 169 plus. So 170 years old university, we have a research excellence and we have a big academic endeavors over the centuries, but there was no patent cell, there was no IP cell. And when I joined this university in 2013, and I found that there is no cell, and there are many faculty members are there, they have patents in their names. Someone was having 10 patents, 50 patents even. They are very much innovative. But unfortunately, there was no IP cell. And if there was no IP cell, I know right now most of the colleges and the universities are building IP cell in their universities and the colleges just because of this NAC requirement. This is a very narrow to me particularly because we have not built up this IP cell in our university, not with that particular motive. I was not interested about this NAC. Yes, that's a byproduct. It might be helpful for our primary missions for that, for developing this IP cell, how we can be much more innovative because most of the cases in the morning, our Vice Chancellor sir has informed possibly, I do not know whether you have understood the thing or not. Patent is a patent right, is a kind of your flat, car, everything. It's a right, your rights over your idea. Yes, the idea is not protectable. It has to be expressed. So, many patents have been given, many patents have been granted in their own name, faculty members' name. Now, the technology that we want to transfer to other companies for commercializations, but unfortunately, we are not the owner. Try to understand. We are doing research over here, our faculty members research, carrying out along with the many research team members, that means the project fellows, research assistants, all are there. But they are not we are not getting any benefit out of that. That's a very difficult thing, because right now, university and the college in some cases, we have to sustain. Sustainability point of view, because everywhere fund is crunched. Shortcomings of fund. UGC is getting closed or UGC is getting dissolved or taking some new shapes, I don't know. But everywhere there is a fund crunch. How to be sustainable, survive in this academic arena. Because the world order, especially after this West Asia fighting, the world order and world dynamics has completely metamorphosed and changed forever. You can easily understand. Instead of this aircraft, we are using drone. So drone is a kind of things, it's a 1962 patent. So right now we are using for our different other purposes. So we have to think over it. Now time has come, we have to encash our research innovations. So with that missions, we started. And we are very much grateful that RUSA and DSTBT, they have given a generous funding, especially RUSA. And just because of that, we could build up this one. And obviously DSTBT, with our team members, they are being encouraged every time by this DSTBT. Dr. Muma came over here. So our team, myself is a coordinator, and I'm accompanied by one Dr. Ujjani Rai and Jishan, who was anchoring. Both are very much, very much well acquainted, and both are actually IP trained and copyright trained, patent trained. And in our department, we have developed in 2014 a special paper with IPR managements. 3 IP interns are there, and they are paid IP interns. They are learning about this. And the IP special paper is the most sought after special paper since 2014 it was introduced. So with this, let's begin with what we have done in this. It was inaugurated in 22nd March 2024, so it's 2 years we have passed. Many things to learn in this journey, and we have many things we have to learn. Create, protect, and foster, this is our motto. I'm not going to this because you have learned a lot on this. What is the missions? Primary missions is the IP awareness. This is the 4th IP workshops. As you know, University of Calcutta has many campuses. This is the 4th IP workshop with the different campuses. We did it in different campuses. And the different topics on the industrial is marked. So we try to protect our assets, IP assets that has been developed by our scientists and the faculty members, and the students and the scholars. What was most important that when we think about something to enforce, we need a policy. There was no IP policy. Everybody can do anything what they like. So first and most important thing is, I thought, and our team thought, the IP policy. We have prepared IP policy. So we'll be discussing a little bit on this IP policy, and it might be helpful. People who came from the colleges, they are also going to set up the different IP cell. With policy, bind people. Policy and discipline is important. And academics, next phase of our cell will be academic program. So I'm not discussing much. In this Global Innovation Index, every year it is published by WIPO and the Cornell University. India is nowhere. Obviously, in the last 10 years, India has escalated its positions, but still a miles to go. Right now, it's in 38 positions. We are doing some research, especially our University of Calcutta, in the last 5 years, how many patents have been granted to us. So this is the graphical positions. You can easily find out the 21. You can remember that dangerous years, difficult phases of our life we have passed through. That's our COVID year. You see the number of patents reflecting that, and it has been increased. and it is attesting. I do not know whether our encouragements, awareness or anything, obviously IPSL has contributed a lot on particular these escalations. So let us think, all faculty members are there and the students are there. Our education systems, when we go for an QS ranking or any kind of ranking, say for our NIRF ranking, everywhere we're thinking about how many patents, how many papers you have written. That means publication-based metrics. Publication-based metrics over the years, right now, whole system is telling that how many innovations. Because, you might have 35,000 citations, but if you do not have a patent, your research has no utility to the society. Yes, it has inflated, it has escalated your CV and your positions and power, but you have not contributed through your science, to the science and nation development. So innovation can be one of the most important thing and based on parameters, but unfortunately we don't have. And that's a paradoxical. So forget about this mathematical calculations, we are doing this. Metric imbalance, incentive distortions, weak technology transfer systems, global south disadvantage. Because as I told you, if I'm not the owner of a particular flat or a car, how can I sell it? Similar thing is happening most of the universities, including us. Because most of the patents have been granted in the name of the faculty members, they have done on their own names. But there is a policy. It is not an IP policy of the University of Calcutta. There is a Patent Act 1970 that clearly says work for hire provisions. If you are working, if you are a student, a scholar of any institutions, whatever inventions you are doing, first owner or assignee would be your institutions. You can be the inventor. But unfortunately, that thing is missing. So knowledge creations, publications, and the patents and the commercialization, only the university can be evaluated properly. So these are the few pictures. These are the pictures from our earlier workshops. So suppose you have inventions, you have did something in your laboratory or something good idea, as many people were saying that. In our university, how we deal it, there is an invention disclosure form. You disclose your inventions before us. All IP related information is very, very confidential. We don't disclose to anyone. So you fill it up. Based on that, we are having a software that is same software that is used by the Indian Patent Office, PATSHEAR. Through this, what we understand the patentability searching, 3 criteria: novelty, non-obviousness, and the industrial applications. We search it and provide a report within 7 to 10 days. Based on that, they can submit their applications. So what is important over here, in the IP policy at a glance, there are 15 articles and 2 annexures. First annexures is the IDF, Invention Disclosure Form, and especially with the inceptions of this generative AI in the November 2022, Gen AI has become in some cases it's a beneficial, in some cases it has become a menace to the academic sanctity. So in that case, we have developed Annexure 2 copyright policy for the University of Calcutta. That is already in our site. You can check it because Gen AI or ChatGPT or DeepSeek, whatever, how you can use ChatGPT or Gen AI for which purposes or on which ground you can use. You have to clarify properly. Because your intellectual capability cannot be escalated by Gen AI because it's already available in the Gen AI because they are using some softwares and the databases. The database is already available. So what is your creative sparks? So that's a very important part. If you're interested, you can go through our copyright policy. So these are the policy university. I will show you the basic things. Overall principles of IP policy: protections, incentives, responsible commercializations, local development, breach or infringement. IPSL is one-stop window. Scope, obviously, in all activities what we carry in our laboratory, or in our classroom. Includes everything, all forms of IP. Responsibilities of the IPS cell: awareness, facilitate, relationship management with the creators, IP management, overall IP management, because the last 25 years data we have already created, 2000 to 2025. Because if you want to sell your product, you must know whether your product is within the range or not, because there are different years are connected. For patent, it's 20 years, and for our copyright, it's 60 years. Author's death, if it is a multiple authors, last author's death, and then 60 years. And then oversight, IP costs and revenue distributions. And we receive a very complicated case regarding copyright. So our team investigates, and investigation is a very confidential. You know, all the IP rights, patent, design, trademarks, and all PBS, everything is covered by civil rights, but this copyright is covered by IPC. Right now it's a Nyaya Sanhita. So it is local police stations, sub-inspector police, they are entitled to go for its investigations if there is any violations or infringement. IP ownerships, as already Vice Chancellor said, and this is also already in the IP policy. We already prepared in 2025. Faculty members, staff members, researchers, students, group students. If there is a visiting faculty, visiting fellow, they can also get some IP, obviously within the terms and conditions. So our IPSL committee is there. Honorable Vice Chancellor is in the apex. Honorable Registrar, myself coordinator, external member, he is also IP attorney, he came in the morning. And 14 faculty members from the different departments, all from, this is because we are having 7 faculty, including all commerce management, starting to science, technology, all faculty members on the different faculties, they are there. So IPSL composition, as I already said, coordinator, 1 research assistant, 1 multitasking staffs, IP, and IP interns are there. Important is expenses, because most of the faculty members, they ask these questions. Yes, we are interested. We are interested to file a patent, but it requires some money. Will you give money? So our IP policy said, yes, we can give you money. Obviously, along with the terms and conditions, and 50% can be given to you. You can apply. Is expenses related, IP expenses related to statutory cost, that means 8,000 plus attorney cost, more or less 42,000 to 43,000. You can take 45,000, we can give you 50% if you submit from the University of Calcutta. And important is sharing IP revenue. If it is commercialized as an inventor, you will also get 50%. So these are the provisions already over here. Commercializations. University wants to commercialize it. University will endeavor to commercialize IP in a manner that enhances the local, regional, and national economic development. Sharing revenues, as I said, 50-50. Yours 50, university 50. And when university gets a 50%, what would happen to that 50% revenue, what university gets as a share? 50% for further research will be used and utilized. 20% for IPSL development, because that's an indispensable and integral part. Because most of the institutions, higher education institutions especially, they are thinking that we are just fulfilling the next criteria because we have to go this NAC accreditations process, so we have to prepare that one. But unfortunately, this is not the things. If you are really serious about the creation and innovation and its protection, and certainly IP cell in any higher education, be it a college or a university, it should be the integral part. In all universities in abroad, they are very, very serious about it, especially US, regarding the copyright and the patent. 10% for further IP prosecutions and the maintenance cost. You know, patent is given for 20 years period of time. When you submit your patent up to second year. From the third year onwards, you have to renew your patent up to 20 years. That requires a substantial amount of money. University is in positions to provide you that money, renewal, provided it fulfills our context, our relevancy, because some patents, academic faculty, they do it just to inflate your CV. Doesn't have much commercial applications. Might have a commercial applications, but still not very viable and feasible applications. So 20% institutional overhead. So the 50% part of this university sharing revenue, that will be shared by this way. IP policy is saying that. And it is a standard policy. And it is based on a WIPO, World Intellectual Property Organization. We have not prepared on our own. We have verified, we have consulted, as I'm a WIPO alumni from Geneva. So we consulted Geneva WIPO office, Indian Patent Office, and many other universities. What are the exact policy and how they are sharing their revenues for the development. So this is the thing. Dispute. Dispute is a very important thing, because in the first session, possibly in the first session, somebody was talking about this. After granting a patent, some of your research team is talking about, yes, madam or sir, I have a contribution to this patent, but you have not mentioned my name as an inventor. My suggestions to that, apart from all these legal and technological issues, before going to the court, try to solve it out of the court. Before going, because patent litigation is a very expensive proposition. Don't go for that. My suggestions is like that. Especially with the chemistry department and the physics department, they have these kinds of problems. So logbook plays a very important and the pivotal role. What is your contribution? That has to be recorded and documented. So this is the invention disclosure form, through which if you have a new idea, you can submit to us. We can tell you whether it's a patentable or not. What are the deficiencies you have? So that's all for me. So happy to help you to protect your inventions. This is our email ID. If you have any questions, please let us know. We'll be happy to help you. Thank you. Okay. Any questions? No. Everybody is pulled down now? Yeah, I understand. Post-lunch session is a very challenging one. Everybody is getting sleepy. Okay, go ahead.
Thank you so much, sir, for the truly enlightening and inspiring speech. We are sincerely grateful for your valuable guidance and for sharing your wisdom and experience with us. It is indeed a privilege to learn from you. We are also happy to announce that we also have among ourselves the Officer of Placement and Training, University of Calcutta, Shri Krishnendu Banerjee, sir. Now we are going to move to the next part, which is a video presentation on intellectual property, which will be presented by an intern of the IPR cell, Siddharth Singh Chetri. I would like to request him to come to the dais and present the video. Thank you.
Thank you for having me here. It is said, innovation begins with an idea and protection begins with an awareness. A very good afternoon to our respected coordinator, sir, esteemed guests, distinguished faculty, research scholars, and students. I, Siddharth Singh Chetri, the IP intern of Intellectual Property Rights Cell, University of Calcutta. It's my honor and privilege to be here representing the cell. The Intellectual Property Rights Cell, University of Calcutta, has prepared a short video entitled Understanding Intellectual Property Rights Cell and the Importance of IPR, Patents, and Copyrights. The video aims to create an awareness and significance of the importance of intellectual property rights, patents, and copyrights in fostering innovation, creativity, and academic excellence. So without taking much time, I now would like to kindly request you to direct your attention towards the screen and watch the video. Thank you.
Every research paper, invention, design, artwork, logo, and even software code begins as an idea in the human mind. But how do we protect these creations of intellect? Welcome to this academic overview on understanding intellectual property, brought to you by Intellectual Property Rights, IPR, CELL. University of Calcutta. What is intellectual property? Intellectual property, commonly known as IP, refers to creations of the human intellect. Unlike land or physical goods, IP is intangible. It protects ideas, innovations, artistic works, symbols, and designs. Even though it cannot be physically touched, IP is legally recognized as property. It can be owned, licensed, transferred, sold, and commercially exploited. What are intellectual property rights, IPR? Intellectual property rights, or IPR, are the legal rights granted to creators and innovators over their intellectual creations. These rights allow the owner to prevent others from using their invention, design, or creative work without permission, usually for a limited period of time. The purpose of IPR is to encourage innovation and creativity while ensuring that society benefits from new knowledge. Categories of IPR. Intellectual property rights are broadly categorized into three groups. 1. Industrial property. 2. Artistic and literary property. 3. Sui generis systems, meaning of its own kind. Industrial property. Patents. A patent is an exclusive right granted by the government for an invention. Under international agreements such as the TRIPS Agreement of the World Trade Organization, patents are protected for a minimum of 20 years from the filing date. To be patentable, an invention must satisfy three key criteria: novelty, inventive step, non-obviousness, industrial applicability. In return, the inventor must fully disclose the invention so that society benefits from increased knowledge. Industrial designs. Industrial designs protect the aesthetic features of an object, such as shape, pattern, texture, or color, not its technical function. Protection under international standards lasts at least 10 years. Trademarks. Trademarks protect distinctive signs, names, logos, symbols, shapes, even colors that identify goods or services. Unlike patents, trademarks can be renewed indefinitely as long as they are in use. Geographical indications, GIs, geographical indications identify products that originate from a specific location and possess qualities linked to that origin, such as Darjeeling tea. They protect regional identity and reputation. Trade secrets. Trade secrets include confidential business information such as formulas, production methods, or client lists. Protection continues as long as secrecy is maintained. Artistic and literary property. Copyright. Copyright protects original literary, artistic, and scientific works. It arises automatically upon creation. No formal registration is required. In India, copyright protection generally lasts for the life of the author plus 60 years. Importantly, copyright protects expression, not ideas themselves. Computer programs are also protected as literary works. Sui generis protection. Sui generis systems provide specialized protection for specific subject matter. Why understanding IP matters? Understanding IP is essential for students, researchers, innovators, and institutions. Before publishing research, filing patents must be considered to preserve novelty. Proper IP management enhances academic reputation, promotes commercialization, and supports innovation ecosystems. How universities can exploit IP. Universities can exploit IP in several structured ways, by commercializing patented technologies through licensing agreements with industry partners, by assigning rights where appropriate, generating revenue for further research and development, by creating spin-off or startup companies. Here comes the role of intellectual property rights, IPR. University of Calcutta. The University of Calcutta is committed to ensuring that intellectual property, IP, emanating from its research activities is used in support of the objectives set out in its charter and statutes, and in accordance with its legal obligations, for the benefit of the university. The cell was established on the 22nd of April 2024 and inaugurated by the Honorable Registrar. The IPR cell is the ultimate decision-making body in the determination of IP management and commercialization strategy for the university. Mission of the IPR cell at the University of Calcutta: 1. IP awareness and training. 2. Capacity building for IP strategy. 3. Advanced research in IPR. 4. Future academic programs, gradually introducing formal academic courses related to IPR in the coming years. 5. Support for inventors, assisting innovators throughout the process, from ideation to patent grant and registration of copyright, trademark, industrial design. Objectives. The main goal of IPR cell within academia is to integrate IPR with the educational process to improve quality of thinking, spread a culture of regard and respect for IPR, ensure prompt and accurate identification and protection of innovations resulting from research work carried out in the university, facilitate the transfer of knowledge and technology from academia to industry, and broaden the scope of their commercialization. The cell also wants to support local innovators. Successful events conducted IPR cell of the University of Calcutta. Inauguration of the IPR cell, the 22nd of March 2024. First one-day workshop on fundamentals of IPR, fostering innovation ecosystem. Second IP workshop on patents, from innovation to commercialization. Third IP workshop on patents, designs and technology management. Thus, guided by the vision to create, protect and foster the intellectual property rights, IPR cell of the University of Calcutta stands as a dedicated platform to promote innovation, awareness, and responsible protection of intellectual assets within the university community. Thank you.
Every major innovation, from life-saving medicines to advanced technologies, begins with an idea. But how do we legally protect such innovations? Welcome to this academic overview on concepts of patents, brought to you by the IPR Cell, University of Calcutta. What is a patent? A patent is an exclusive right granted for an invention. Patents benefit inventors by providing them with legal protection of their inventions. Under the Indian patent system, the term of a patent is 20 years from the date of filing. A patent grants the patentee the exclusive right to make, use, sell, import, license, or assign the invention within the territory where the patent is granted. What is an invention? An invention is a product or a process that provides a new way of doing something, or offers a new technical solution to a problem that surpasses trivial solutions. What kinds of inventions can be protected? Patents may be granted for inventions in any field of technology, from an everyday kitchen utensil to a nanotechnology chip. Why protect inventions with patents? The patent owner has the exclusive right to prevent or stop others from commercially exploiting the patented invention for a limited period within the country or region in which the patent was granted. Criteria of patentability. For an invention to be patentable in India, it must satisfy the following essential conditions. 1. Novelty. 2. Inventive. Step 3. Industrial applicability. 4. Not fall under sections 3 and 4. What cannot be patented in India? Even if an invention is novel and inventive, it may not qualify for a patent if it falls under non-patentable categories, such as mathematical methods, algorithms, methods of medical treatment, discovery of scientific principles, patent filing and examination process, filing of application. 2. Publication, after 18 months unless early publication requested. 3. Request for examination, within 31 months from priority date. 4. Issuance of first examination report, FER. 5. Response to objections within prescribed timeline. 6. Grant or refusal. What is the PCT system? The Patent Cooperation Treaty, PCT, establishes a cost-effective means for companies and innovators to seek patent protection for inventions in multiple countries. A single international patent application successfully filed under the PCT, also called PCT application, has the same legal effect as filing separate patent applications in all contracting states. It currently has 158 contracting states. Who can use the PCT system? You can file an international application under the PCT, also called PCT application, if you are a national or resident of a country that is a PCT contracting state. Where can I file a PCT application? You should file with a patent office that is competent to receive your PCT application, known as a PCT receiving office. How much does it cost to file a PCT application? You must pay 3 fees to the receiving office when filing your PCT application. For more details, visit the official website. How to file a PCT application? The application must include the following. What are the benefits of the PCT? First, it is more convenient than filing separate national patent applications in multiple countries, as your single PCT application is recognized in all contracting states as having the same effect as a national application. Second, you will have more time to decide whether you would like to further pursue your application before any interested national office. Third, you will be provided with expert opinions on the potential patentability of your invention, and thus be better informed to make decisions during the process. Last but not the least, using the PCT can help you save effort and unnecessary cost in seeking patent protection in a number of countries. What are patents rules? Under Section 159 of the Patents Act 1970, the central government can create rules for patent administration. Subsequent amendments occurred with the Patents Amendment Rules, 2005, and the Patents Amendment Rules, 2006, with the latter effective from May 5, 2006. To do IP filing through IPR Cell, follow these steps. thank you for watching the video. You can contact us by the given details below.
Thank you so much, Siddharth, for such an informative video presentation. Now we are moving to an interactive segment, the question and answer session, where you will have the opportunity to clarify your queries and engage further on the topic. This session will be conducted by our IPR cell interns, Rajlakshmi Paul and Amisha Singh. And a surprise is there. There will be gift prizes for the winners of this question answer round. And prizes will be a coffee mug, a very beautiful coffee mug with the logo of our IPR cell. So they will explain the rules and regulations of the question answer round, and this interactive session, I hope you will all get the energy with this session. Thank you.
A very good afternoon to everyone. I hope you all enjoyed this insightful session we just had.
We are truly grateful to Professor Dr. Shobuj Kumar Chaudhary for giving us such a wonderful opportunity where we could learn more about IPR, and also to all the speakers who enlightened us with their knowledge.
We would also like to extend our heartfelt thanks to Dr. Ujjainire Jishanda, our volunteers, and everyone who worked behind the scenes to make this workshop successful.
Your efforts and guidance mean a lot to us.
So let's give a big round of applause to all of them.
Now, it's time to make things a little more fun and interactive. So shake out those fingers and wake up those brain cells.
So please look at the screen. There is a QR code appearing. So what you need to do, just scan it, and it will take you to a Google form.
The form has 10 questions based on what has been discussed today about patents and copyright.
Don't worry, the questions are simple and options are already given. So what you need to do, just choose the correct answer.
You have 15 minutes to answer 10 questions. It's a race against the clock, so relax, think, and enjoy answering.
And the exciting part of once you submit, you can instantly see your score. No more waiting. And if you need any kind of help or need any kind of question that you might ask, please feel free to ask our volunteers.
Also, there is a feedback section at the end. Your feedback truly matters to us. It helps us learn, improve, and bring even better sessions for you in the future, so please share it honestly.
So the clock is ticking. Take out your phones and scan the code and give your best. Let's not just learn about IPR, but truly respect and protect creativity. Every idea has values. Let's work together to protect its beauty and inspire others to do the same. And thank you. Best of luck.
We'll meet again after 15 minutes. It's 5:29 right now. You have time till 5:45.
Your time starts now.
If you have any difficulty scanning on the screen, you can ask our volunteers. They also have the image. They can help you out.
If anybody faces any kind of problem or difficulty scanning this QR code, please feel free to ask our volunteers. They are here to help you.
You have 5 more minutes.
You have 1 minute left. Please submit your questions. Time's up, pencil down, or more accurately, fingers off screen. We hope you have completed your responses.
Whatever the scores are, remember the goal here is the same, encouraging innovation and rewarding creators. That is the heart of the CUIP policy. And if you made some silly mistakes, don't worry, your secret is safe with us, and the server logs, of course.
Exactly. We hope you enjoyed the small interactive session and also learned something new through it. Congratulations to everyone who participated. Thank you once again for being such a wonderful audience. And now we will call some of the IPR champion, and you may please come on the stage to get your gifts. We
we have received over 124 responses. So we chose the participants who scored 10 on 10 on the very first try. So I'm going to name you all and please come on stage one by one. Shrideep Dey. Sir, will you please come to the stage to give him?
Utshav Paul, please come up on the stage.
Utshav Paul. No, I say Shrideep Dey. Shruti Bhattu. You are also there.
Shruti Bhatta, thank you. Utshav Paul.
Priyojit Shane. Priyojit Shane.
Momi Bhawal. Are you there? Please come up on the stage. Snigdha Dash.
Snigdha Dash.
Snigdha Dash.
Adrika Mukherjee. Shupriya Bar, please come to the stage. Adrika Mukherjee, Shupriya Bar.
Ayesha Sarkar.
And Shobik Mondol.
Shomik Mondol.
Priyojit Shane, are you there?
Shomik Mondol.
in their areas. I would also like to thank the principal and faculty members of Loreto College, and also faculty members of all the invited colleges for being present today for the program. I would like to thank the staff of IPR Cell, our volunteers, the staff members of the university for being present at today's workshop. The people working at the backstage, the audiovisual system, AC, electricity, Wi-Fi, thank you all. Without your help, the program would not have been possible. Lastly, I would like to thank our audience for being patient and sitting till the end of the program, although we are running late. Thank you so much. And with this, I conclude this ceremony. Tea and biscuits has been arranged outside. Kindly help yourself. Thank you so much.
Dr. Roy Ujjwani Roy has named everybody. She has not named her name. So, as a coordinator, it's my responsibility as well as feelings to say about her, because without her active help, and she actually the driving force of the whole program. So, heartfelt congratulations and the best wishes for our Dr. Ujjwani Roy for arranging such a big program, because this big program is not possible without somebody's driving force. So she was the driving force. Thank you, and a big applause to Dr. Ujjwani Roy. Thank you.